Good morning. This is Board President Sonia Early of the California Physician Assistant Board. I would like to call the meeting to order. It is now 8:36 and today's date is May 20th, 2024. Ms. Herr, would you please call the roll?
Good morning. Charles Alexander,
Present.
Juan Armenta, Sonia Early,
Present.
Randy Hawkins, Diego Insunza,
Present.
Vasco Diankid,
Present.
Deborah Snow. Present. That concludes the roll call.
Excellent. We have a quorum, so we'll move on to the first action item on the agenda, and that is approval of the March 4th, 2024 board meeting minutes. I trust that everyone has had an opportunity to review those minutes. Are there any additions or corrections to those minutes from the board members? Excellent. Hearing none. May I have a motion to approve the minutes?
This is Deanna. I'll motion to approve the March 20 minutes.
Excellent. Is there a second?
Second.
So-
Sorry about that.
Charles Alexander, a second.
Excellent. Do we have any public comments from members using WebEx or in the room?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests for public comment, would you like me to close the Q&A panel?
Yes, please. Awesome. Ms. Herr, can you call for a vote?
Charles Alexander,
Aye.
Juan Armenta, Sonia Early,
Aye.
Diego Insunza,
Aye.
Vasco Diankid,
Aye.
Deborah Snow.
Aye.
And that concludes the votes.
Excellent. The meetings minutes are approved. Next, we're moving on to item number 4, public comment on items not on the agenda. And I just want to make a note that the board may not discuss or take any action on any matter raised during the public comment section that is not included on the agenda, except to decide whether to place the matter on an agenda for a future meeting. Any questions or comments from the floor? Is there any public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and it appears there are no requests for public comment on WebEx. Would you like me to close the Q&A panel?
Please. Excellent. All right. So we'll move on to item number 5. That's the president's report. This week, we recently received news for some prestigious, noteworthy recognition from our own Vice President Kidd. He was featured in the Becker's 231 Black Healthcare Leaders to Know in 2024. We wanted to give him a congratulations and give him the opportunity to tell us a little bit more about that prestigious recognition.
Thank you, President Hurley. Thank you, everyone, board members. It's Becker's is a trade magazine. It's one of the most widely read publications. A lot of healthcare executives and leaders within the healthcare space typically read that magazine. And so to be listed in the 231 is a very prestigious honor, and I'm humbled to be listed among other great leaders and outstanding healthcare providers and administrators. So thank you, everyone. Appreciate the opportunity. And again, thank you, President Hurley.
Congratulations. Congratulations again. Excellent. Awesome. We're going to move out of order. We're going to go to the DCA budget update. We'll take that now. And that's item number 6. Oh, all right.
Thank you. Good morning. Thank you for allowing me to present today. My name is Andrew Trudy, and I'm the budget analyst with DCA's budget office. With me is Suzanne Balkus, the budget manager. I'm here to present the board's 23-24 FM9 projection memo, expenditure, and fund condition. Please refer to agenda item 9. We're going to start with the budget memo. This will give you a general overview of the board's budget, as well as percentage of the budget used and counted towards expenditure. In 23-24, the board has a budget of $3,325,000. The board is projected to use 38.38% of its expenditure on personal services, which includes salaries and benefits. 34.87% of OE&E, which includes contracts, purchases, and travel. Finally, 26.04% for enforcement, which is for contracts, for Office of Administration Hearings, or OAH, and Attorney General, AG. The board is estimated to have a 0.71% in reversion. On the second page, we have the fund condition. We have 2022-23 actual beginning balance of about 4.5 million with prior year's adjustment of 51,000. That gives us an adjusted beginning balance of about 4.55 million. We have an overall revenue of 2.8 million and total expenditure of about 3.1 million. That gives you a fund balance of 4.2 million, which is about 15.0 months in reserve. Next is current year 23-24, second column, which has FM9 projections included into it. 23-24 beginning balance of about 4.2 million. We have an estimated revenue of about 2.96 million and estimated total expenditure of about 3.4 million. That gives us a fund balance of 3.8 million, which is about 13.2 months in reserve. Budget year is based on governor's budget, and budget year +1 is based on realized. We have no immediate concern for this fund. Next document we have is FM9 23-24 projected expenditure. We have $1.3 million in personnel services and about $2 million in OE&E expenses, for a total of about $3.3 million, which created a surplus of about $24,000, or a little under 1%. We are monitoring the fund and have no immediate concern. I'm available if you have any questions.
Excellent. Do we have any questions or comments from the members? Any question or comment from the floor? And do we have any comments on WebEx?
This is the moderator. At the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests for public comment, would you like me to close the Q&A panel?
Yes, please. Excellent. So moving back on schedule, we'll move to my item number 7, which is the Executive Officer's Report by Ms. Khan.
Good morning.
Good morning, everyone. I will start off with personnel. I'm pleased to announce that effective April 8, 2024, Pearl Herr has been promoted to the Administrative Analyst position. Since joining the board on November 7th, 2023, as the Enforcement and Licensing Support Technician, Ms. Herr has consistently demonstrated dedication and proficiency in her work. Her skills and commitment to excellence has made her a valuable asset to our team. Congratulations to Ms. Herr on this well-deserved promotion, and we have full confidence that she will excel in her new role. Recruitment is underway to fill the vacant Enforcement and Licensing Support Technician position. Board staff anticipates filling this position soon. Additionally, effective May 31st, 2024, Linda Serrano will be joining the board as the new complaint analyst. Ms. Serrano's extensive 12 years of experience as a complaint analyst with the Medical Board of California allows her to bring valuable expertise in analyzing complaints and conducting desk investigations to this role. We are confident that her skills and background will greatly enhance our team's ability to address consumer complaints while upholding regulatory standards. The next item is the 2025 Sunset Review Process Overview. The Sunset Review process involves joint oversight hearings by the California State Assembly Business and Professions Committee and the Senate Business Professions and Economic Development Committee, known as Joint Oversight Committee. to evaluate boards and bureaus under the Department of Consumer Affairs, DCA. This process allows the DCA, the legislature, the boards, and interested parties and stakeholders to discuss board performance and propose improvements. Key steps include drafting a sunset review report, engaging in legislative committee hearings, and potentially extending a board sunset date through the legislature. The process typically begins with the distribution of a sunset template by the Joint Oversight Committee in May or June, outlining specific data and information requirements. Board staff then drafts the sunset review report for board review, discussion, and approval. Initial drafts are expected to be presented at the August meeting, with the final draft ready for approval by the November board meeting. To meet the December 1st submission deadline to the legislature, the board may convene additional meetings outside of its regular quarterly meetings. In February or March of the following year, the board sunset extension bill is introduced, initiating legislative committee hearings. Approximately 10 days prior to the sunset hearing, the board receives a background paper from the Joint Oversight Committee assessing the board's performance since the last sunset review and guiding the board's response to address any raised issues. During the legislative hearing, the board president, vice president, and the executive officer testify representing the board's interests. Subsequently, the board is given 30 days to provide written response to the background paper and address any additional inquiries raised. Finally, if no significant concerns arise during the process, the legislature extends the board's sunset date by another 4 years, ensuring its continued operation and oversight. That concludes my report. Are there any questions?
Thank you, Ms. Khan. Questions on the floor? All right, is there any public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no request for public comment on WebEx, would you like me to close the Q&A panel?
Yes, please. Thank you. Awesome. We'll move on to agenda item number 8. That's board activity reports. We'll start off with licensing from Ms. Caldwell.
Morning.
Good morning.
Okay, so the first report is a licensing population by type. And this just gives you an overall breakdown of the different types of licenses going on. We have 2 licensing types. We have a physician assistant full licensure, and then we have a temporary license. The full licensure can be in different statuses, anywhere from current to delinquent, canceled to retired, and so on. And so this breaks down those different statuses as well as identifies how many total licensees we have, 26,132, and how many temporary physician assistant licenses we've issued to date, which is 3. The next report, which is, I'm not sure what page of the book it is, sorry. But it's item 7B, I believe. This is a summary of the licensing activity. And so this shows you between January 1st of 2024 and March 31st of 2024, we had a total of 462 initial applications for an initial license received, and we approved 429 of those. And we had 2,165 individuals renew their license. And we had a total of 2 applications received for the temporary license. Pending application workload. This gives you a breakdown of the time that the application is submitted with payment, because that's when we consider that a completed application. and it's ready to be reviewed. And the time that it is being processed by staff analysts, so that's the difference. The desk age is from the beginning date of submission, and the application age is the beginning date that it gets assigned to an individual. And that the 0 to 30, 31 to 60, 61 to 90, 91 plus, that's only giving you information of how long the application's been in the system. We are still meeting our deadline, and that's set by our executive officer, our assistant executive officer, and the licensing unit, that we feel it's a fair amount of time for our licensing staff to review the applications within 30 days and provide the individual with an update. So we're still meeting that time range, but those dates that are in the different colors, that just shows you where that person is at in the application review process and hanging out before licensure. And the delay in licensure could be multiple factors. But we have reviewed these individuals. They are aware of what the deficiencies are for licensure. And then the licensing performance measures, that does show you that during this time period of January 1st to March 31st, we averaged about 31 days to provide somebody with an update. And that gives you a little bit more explanation as far as the complete applications, incomplete applications, that we do issue them within several days of the application being completed. We do issue their license, and they're all notified by email if they have an email address on file. If not, a letter goes out by mail. Question?
Yes, I do have a question.
Sure.
Can you explain the parameters around the temporary physician assistant license?
What do you mean by parameters? The length of time that it's good
Time,
for?
or who gets it, or how do you apply for it?
So the requirements for, to apply for a temporary license or a spouse, military partner, domestic partner of an individual that's in the armed forces. And so they can apply for a license, and the requirements for licensure are less than a full licensure. So the application has to be submitted. We do waive their fees. They do have to have a background check. They do have to provide their marriage certificate, their orders, and they have to provide evidence that they're currently licensed as a physician assistant in another state. And so those are the minimum requirements. They differ a little bit from what full licensure is. They don't have to provide evidence of graduating from a program, successful passing of the PANCE examination with the NCCPA. If they have multiple licenses as a physician assistant or any other healthcare provider, they don't have to provide any of those on the application, or do they have to be verified. It's just one physician assistant license in another state that's in good standing. If they know that they're not in good standing in another state, say they have 3 or 4 different physician assistant licenses, and one of those has disciplinary, there's an open complaint, they're not supposed to apply for a temporary license. They have to be in good standing in all the states, but they only have to disclose one state, and then we get the verification directly from that state before the license is issued. So what we're receiving in order to approve is the background check, the results of the background check, and verification of that license from that other state. So, and the license is good for 12 months. They don't receive any type of documentation. They can visit the board's website, and they can view their licensing detail from the board's website, and that's the only written documentation that we provide, and it's only valid for 12 months. They do have to apply for full licensure before that license expires if they don't want any disruption in their ability to provide services for which a medical license issued by the Physician Assistant Board is required.
Excellent.
Okay.
Any other questions or comments?
Great report. Thank you.
You're welcome.
Excellent. Thank you, Ms. Caldwell. All right, moving on to B, which is complaints by Mr. Melendez.
Good morning.
Morning.
I'll be providing you a section of the enforcement activity report in regards to the complaints for the third quarter. We will be focusing on the third quarter from January 1st, 2024 to March 31st, 2024. As you can see, we have also provided stats from the previous year. This report will also show how we are trending this fiscal year. We have complaint volume. We have received 114 complaints for the quarter. We have convictions and arrests. We have received 3, with a total of 117 complaints. Intake. Intake average days at this point are 4 days. We have 0 complaints that are pending at the intake. Complaints and investigations. We have 6 complaints that were referred to the field for further investigation. Complaints and investigations that were closed. We have 150 that were closed this quarter. We have 285 complaints pending at the desk analyst. We have 38 investigations that are pending at the field currently. Investigation aging. The average age of pending investigations are at 343 days. Investigations 8 months older, there are currently 31 cases. I would like to move to the following chart. The following chart is is on the complaints received by type and source. And this concludes my portion of the report. Thank you. And if you have any questions, please ask.
Thank you. Excellent report. It looks like our numbers are moving down and we're in the right direction. So great job.
Thank you.
Are there any questions or comments? Okay, thank you, Mr. Melendez.
Thank you very much.
At the end. We'll move on to C, discipline with Ms. Hayden.
Good morning, everyone.
Good morning.
I'll be presenting the discipline statistics for the third quarter, which is January 1st, 2024 through March 31st of 2024. For the suspensions, there are none for this quarter. For the Office of the Attorney General transmittal, we had 6 cases initiated, 47 cases pending, and the average age of pending cases is 432. For the formal actions filed, withdrawn, and dismissed, we had 5 accusations filed, 1 accusation withdrawn and dismissed, and 1 statement of issues was filed. The next page is the administrative outcomes and the final order. 2 licensees were placed on probation. 1 license was revoked. 2 licenses were surrendered. And now we go to the citation and fines. This quarter, there were 16 citations issued. 3 were resolved, closed. 13 are pending. And there was $4,250 of fines issued. And the fines received for this quarter is $750. That concludes my report. Does anyone have any questions? No?
I just have a quick question.
Sure.
Is that is there a certain time frame for the fines to come in total?
We give them 60 days.
60 days?
Yes.
All right, great. So they're probably in that 60-day window.
Yes.
Perfect. Any other questions or comments from Ms. Hayden? Excellent. Thank you, Ms. Hayden. We'll move on to D, probation with Ms. Gerard. Morning.
Morning, Madam President, board members. Congratulations, Mr. Kidd. Okay, probation activity report. In January, we started with 41 licensees on probation. One of the folks that was tolling in another state surrendered, so that's good. They didn't really want to come back. February, we didn't have much activity, and in March, 2 people entered and 3 successfully completed probations. We ended out with 39 people at the end of March. Does
Okay.
anyone have any questions?
Excellent. Any questions? Perfect. We'll have you stay on and do diversion. Thank you, Ms. Gerard.
Okay. Thank you, ma'am. Okay, we started with 4 licensees in the diversion program, and things remained the same until March when one of the people on probation was deemed a candidate. And so then we ended the quarter with 5 in the diversion program.
Excellent. Any questions for Ms. Gerard? Perfect. Thank you so much, Ms. Gerard.
Thank you, ma'am.
Welcome. Do we have any public comment or on the floor?
This is the moderator, not the direction of the board. I have opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests for public comment on WebEx, would you like me to close the Q&A panel?
Yes, please. Excellent. We are moving on, and I think we took the budget update already, so we will move on to the next agenda item. That's Department of Consumer Affairs Director's Update.
Good morning.
Good morning.
Well, my name is Judy Bucciarelli from the DCA Board and Bureau Relations. It's great to be with you again today. On behalf of the department, I would like to thank all the board for your service and dedication to protect the consumers of California. To begin the update today, May 5th through the 11th was Public Service Recognition Week, and DCA honored the 3,000 departmental, board, and bureau employees dedicating to protecting California consumers. DCA would like to thank all employees for their service and contributions to consumer protection. On April 30th, DCA hosted an in-person meeting with Agent Secretary Tamika Moss and executive leadership. The meeting served as an opportunity for DCA leaders to meet our new secretary and hear her vision and priorities for the Business Consumer Services and Housing Agency and the department. Next, DCA has learned of a recent increase in scams targeting licensees. Though the nature of the scams varies, they are similar in that they involve individuals falsely identifying themselves as board employees and telling the licensee they are under investigation. The scammers attempt to gather personal and/or financial information and may even demand payment. Boards are urged to be vigilant and proactive in providing licensees with tips on avoiding scams. Next, I have a diversity, equity, and inclusion update. On April 5th, DCA's Diversity, Equity, and Inclusion, also referred to as DEI, Steering Committee held its quarterly meeting. The committee reviewed and discussed the member application process, establishing subcommittees, and solicited input from committee members on how to expand language access, workforce development, and advance DEI activities in 2024. The next committee meeting will be held on July 26. If you have any ideas that you would like the committee to consider, please share them with your executive officer. As a reminder, DCA's learning management system has many DEI-related training courses available. Next, last month, DCA's Office of Public Affairs staff participated in 2 Facebook Live events hosted by the Consulate of Mexico's Sacramento and Fresno offices during its Financial Education Week. Staff presented Get to Know DCA in Spanish and shared a broad overview of consumer and licensing information. In addition, DCA joined an in-person resource event with the Consulate of Mexico in Sacramento. Another Get to Know DCA virtual event was held with the Consulate of Mexico in San Bernardino on May 14th. The consulates have expressed interest in future event partnerships to share even more licensing and consumer resources. In the coming months, DCA will be developing workforce development outreach opportunities for all boards and bureaus to participate in. I look forward to sharing more information with you soon. Next, as the fiscal year comes to an end, please submit your travel expense claims as soon as possible and no later than Wednesday, June 7th. Claims submitted after this date will still be processed. However, the State Controller's Office will not issue payments until after July 5th. All travel expenses and advances submitted for travel on or after July 1 will be processed for payment after the budget is signed. For any questions regarding travel claims, please contact DCA Board and Bureau Relations. As a reminder, board members must complete BMOT, which is Board Member Orientation Training, within 1 year of their appointment or reappointment. This training will be offered virtually on June 18th and again on October 22nd, 2024. Members can register for BMOT training via the Learning Management System. Next, now that the annual Form 700 filing period is in, DCA and BBR would like to thank all board members and executive officers for helping to achieve nearly 100% compliance. This concludes the DCA update, and if further information or assistance is needed with any of the items I've shared with you today, please feel free to reach out to Board and Bureau Relations. And at this time, I'll hand it back to President Early, and I welcome any questions from the board.
Excellent. Thank you, Ms. Bucciarelli. I appreciate you. Awesome. All right. So it looks like we're back on schedule. And so I will, do we have any public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests for public comment on WebEx, would you like me to close the Q&A panel?
Yes, please. Awesome. We will move to item number 10, and that is Medical Board Report by Dr. Hawkins.
Can you hear me now?
Yes.
Okay, great. Well, good morning again, and thanks for this opportunity to report on some of the important activities of the Medical Board of California and our PA Board. This will be my last report as a president and a board member of the Medical Board of California. I was initially appointed to the Medical Board in 2015 by Governor Edmund Brown and reappointed twice by Governor Gavin Newsom. I term out June 1st after 9 years on the Medical Board. My appointment to the PA Board continues. The Medical Board of California last met February 29th and March 1st, 2024 in person in Los Angeles. The Medical Board will next meet later this week in Sacramento on Thursday and Friday, May 23rd and 24th respectively. The agenda is attached the agenda is available at mbc.ca.gov. Some new highlights of the PA Medical Board include, I want to draw attention to the Medical Board's agenda of Friday, this Friday, May 24th. The board will convene at 9 a.m. and the first agenda item is presentation on successful elements of physician health programs. There'll be two subject area experts representing two separate programs. The in-person location is the California Board of Accountancy at 2450 Ventura Oaks Way, Suite 420, Sacramento. I encourage PAB staff, especially those in leadership, to view this presentation. Next, the Federation of State Medical Boards, FSMB, last met April 17th to 21st, 2024 in Nashville, Tennessee. I participated remotely as a delegate on April 20th. My participation involved election of certain officers, voting on amendments to bylaws, adoption of various position statements, guidelines, and resolution, and other things. I refer you to the FSMB website for details at fsmb.org. I also want to draw your attention to a number of PA-related issues for your consideration that occurred at this meeting. The first, physician associate was a title used at times in the meeting. CAPA was present at this meeting. Rosanna Khan and I discussed this FSMB meeting briefly afterwards. Next, PA Licensure Compact is now enacted in 9 states. However, it's not fully operational in any state. California is not included in the PA Licensure Compact. Next, post-licensure medical assessment of physician assistants was referred to the Board of Directors of SMB for action. Resolution 24-1. Testimony was heard from the National Commission of Certification of Physician Assistants for information. The AAPA spoke in opposition to this resolution. Finally, in this category, guidelines for the structure and function of a state medical and osteopathic board was adopted by the House of Delegates 2024, superseding a previous edition. See section X1X, physician assistants, pages 42 to 43. I have a brief commentary before I go on with my report. In my opinion, personal opinion, it's more than unfortunate that members of the boards of such an important board, PA board, cannot really attend out-of-state events. Similarly, the medical board is unable to attend. I attended a Federal State Medical Board on Artificial Intelligence in January. And even though myself and the executive director ordered a scholarship at SMB, we could not accept the scholarship for travel. So I paid because I was going to go to the East Coast and I could see my son and daughter. But then I wasn't able to give a report about it. And so here, so you can hear there are very, very important things going on, and we're not able to represent in a way we'd like to. And that's the end of my commentary. Next, continue to a different subject. Task force appointments. The medical board will be reviewing the mental and physical health questions on the physician licensing application. I will be appointing a task force of 2 board members to assist. As part of this review, the board will be holding interested party meetings in the future. Finally, and not least important, maternal mortality issues were presented and discussed at length at our medical board meeting in August 2023 in Bakersfield. I participated in observership at the last California Pregnancy Associated Review Committee, CAPRC, meeting April 19, 2024. The primary focus of the review the primary focus of the review is to work on the clinical side of preventable causes of maternal death. California is far from the highest, but our numbers are not going down in maternal mortality. These primarily involve areas of hypertension, infection, uncontrolled bleeding, and cardiovascular factors. It is recognized, however, complex social issues are often present. This review, in my opinion, that is the California Pregnancy Associate Review Committee, was a comprehensive, thoughtful, inclusive, respectful process. Multiple physicians were part of the review process and included specialists in the areas of obstetrics, anesthesia, emergency room, pathology, and cardiology. Additional disciplines included social work, epidemiology, public health, and nurses. For more information, I refer you to the California Department of Public Health, that is cdph.ca.gov, and query CA-PRC, where you can view upcoming related events, toolkits, and collaborative organization. This ends my report. Thanks for the opportunity to participate again.
Thank you, Dr. Hawkins, and I concur with your commentary. Do we have any other comments or questions?
Dr. Hawkins, number one, thank you for your service on the medical board. Absolutely outstanding. And thank you for your awesome report. Quick question that I have, the compact legislation, it is my understanding that once 7 states have adopted the compact model legislation, that it would actually go into effect. Usually it would take about 24 months for that to occur, is what the AAPA is estimating. So the fact that we have 9 states means that it's going to be operational in probably about 2 years.
What about the state of California? Does it require legislation?
It would, yeah. State of California has not yet joined the compact states as it is today. But those 9 states that you mentioned earlier will be able to operationalize the compact legislation within the next 24 months.
Great.
Excellent. Any other questions or comments?
May I ask, Rosanna, you and I spoke briefly, it was a while ago, we talked. And I don't know if, has any leadership been to FSMB or?
We did last year and we were really disappointed that we couldn't go this year. So, yeah.
Excellent. Do we have any public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests for public comment, would you like me to close the Q&A panel?
Yes, please. Thank you. All right, we'll move on to agenda item. Thank you again, Dr. Hawkins, for that report. We'll move on to agenda item number 11, where we have discussion and possible action on rulemaking proposal to amend Title 16 California Code of Regulations, Section 13.99.52, 0.540, 0.541, and 0.545, and SB 697 implementation by Christy Shields and Ms. Dillon.
Good morning, everyone. Christy Shields, Regulations Counsel for the Board.
Good morning, Jasmine Dillon, Legislative and Regulatory Specialist for the board.
So on item 11, we have 3 different action items for your review. The first one is discussion of possible action on rulemaking proposal to amend Title 16 California Code of Regulations, Sections 1399.502, 1399.540, 1399.541, and 1399.545 SB 697 implementation. Consideration of public comments received during the 15-day public comment period on second modified text and proposed responses thereto. So as you know, at our last board meeting, the board approved the second modified text and adopted the revised regulatory language in response to comments received. The second modified text is included in your packet in attachment 1. The second 15-day public comment period began on March 7th and ended on March 22nd, 2024. And the board received 2 comments. One in support of proposed second modified text from Scott Martin on behalf of the California Academy of PAs, and another comment letter with objections and recommendations from Senior Legal Counsel on behalf of the California Medical Association. I draw the board's attention to page 2 of the memo where the summary of the comments received and the proposed responses are included there for your review. As part of the rulemaking process, the board is required to include in its final statement of reasons a summary of each comment and objection or recommendation and the reasons for making or not making a change in response to those comments. So the first comment received from CAPA was received March 20th, 2024, and that comment offered CAPA's enthusiastic support to the proposed regulatory language by the board, released March 7th, and commends the board for its proposed amendments, which correctly, in its view, correctly implement the legislative intent of SB 697. And the proposed response recommended by staff and myself are to accept the support and notify CAPA that they intend to proceed with the adoption of the proposed language as set forth in the second modified text. The second comment letter received from the California Medical Association, CMA, was received March 22nd, 2024. There were 3 adverse comments and recommendations or objections received in that letter. The first comment, the CMA agrees that the prior language requiring a PA to ensure that a supervising physician review a PA's training improperly places the supervising physician's responsibility on the PA. However, CMA disagrees with the argument that the board lacks authority to impose any requirements on the verification of a PA's training and qualifications beyond the existence of a practice agreement. As a result, CMA recommended a modification to 16 CCR 1399.541 I1 that adds language requiring the supervising physician to review documentation when a physician assistant performs surgical procedures under anesthesia. And that language is bolded for your review on page 3 at the top. Second paragraph, a physician assistant shall not perform surgical procedures under anesthesia or sedation unless the supervising physician reviews documentation which indicates that the physician assistant is trained and qualified to perform the surgical procedures under such anesthesia or sedation. And you, as you can see, the proposed response would be to reject that comment. And basically highlighting what the arguments were are that SB 697 struck the board's previous rulemaking authority at B&P Code Section 3502 to establish alternative mechanisms for the adequate supervision of physician assistants by regulation. The prior language in the act for your review used to state that notwithstanding any other law, the Medical Board of California or this board may establish other alternative mechanisms for the adequate supervision of the physician assistant. That was struck by SB 697. Instead, Business and Professions Code Section 3502 now provides that notwithstanding any other law, a PA may perform medical services as authorized by this chapter, and there's a specified list of things that the PA has to meet in order to perform those services, none of which includes complying with any regulations adopted by this board. In addition, there's the legislative history to support the interpretation. I've attached a copy of a committee analysis, the Assembly B&P Committee analysis dated July 1st, 2019. That's at attachment 4. And then highlighted one of the analyses from that committee analysis, which is that the law was intended to allow physicians and PAs to determine for themselves the appropriate level of supervision with every licensee involved in a specific practice agreement, subject to discipline for improper supervision. I also note that in the legislative analysis in attachment 4, CMA supported the bill. And if you look on page 5 at the top of the memo, I've highlighted one of the statements in the support, and CMA indicates finally this bill allows for more autonomy to each medical practice as to their functional relationship with their physician assistants. We believe these administrative fixes will help to alleviate the burdens of working with physician assistants and increase the capacity of physicians and physician assistants to address critical access to care. So the recommendation would be to reject that comment and avoid a conflict with the express authority in BPC Section 3502. So that's the first comment. The second comment, CMA objects to the board's proposed deletion of language in 16 CCR Section 1399.54 I1 and 2 that required a supervising physician to be immediately available when a PA performs or participates in surgical procedures under anesthesia or sedation, as well as deletion of a definition of immediately available in paragraph I3. And so the recommendation is that we retain that text. The recommended response is the board acknowledges receipt and review of the comment, but decided not to make the modifications suggested by the CMA. And the analysis is pretty extensive in response to that comment, starts on page 6 at the top. But the high points are that to reject the comment because the plain meaning of BPC Section 3501 controls, and reiterate the requirements in 3501 F1, Section 3501 F1 of the Business and Professions Code, that supervision shall not be construed to require the physical presence of the physician and surgeon, but does require adherence to adequate supervision as agreed in the practice agreement, and the physician and surgeon being available by telephone or other electronic communication method at the time the PA examines the patient. The board is only authorized to limit PA practice under the authority in BPC Section 3501 F2, which states, nothing in this subdivision shall be construed as prohibiting the board from requiring the physical presence of a physician and surgeon as a term or condition of a PA's reinstatement, probation, or imposing discipline. The second argument is that the board's not authorized to rewrite the statute, and there's some legal authority for that argument, and the legislative history, which is attached in attachment 4, supports the board's interpretation. What I think is noteworthy is in page 7 and 8 of the committee analysis, The board at the time, while the bill was going through with the language we've discussed, the board lodged an oppose unless amended position seeking an amendment to the definition of supervision to allow for the physical presence of a physician, arguing that the language shall not be construed prevents this board, and the medical board from disciplining a licensee when patient harm resulted from practice agreement that did not require physical presence. The striking of the language limiting regulations is another issue, but the other issue was this board at the time requested reauthorization of the board to establish regulations that limit the services a PA may perform. So we got some of that argument addressed and some not. And the part that was not addressed was to allow us to specify limitations on practice. The legislature did acknowledge the board's right to discipline and take action with relate to failures in the part of supervision in the relationship. So the medical board and the PA board still have that authority. And so, again, that comment recommended was rejection. The third comment objects to the deletion of CCR section 1399.545B, which required a practice agreement to establish procedures, or requires, I should say, a practice agreement to establish procedures for the immediate care of patients in need of emergency care beyond the PA's training and competency. And the recommendation would be to reject that comment as well because of the arguments that we previously discussed, and that the board can no longer generally limit the services a PA can provide in a practice agreement except in those instances specified in BPC section 3501F2. SB 697 has changed the law so that such determinations are generally determined at the practice level between the physician assistants and the supervising physicians in accordance with Business and Professions Code section 3502. So that's kind of the high level summary of the comments and the recommended responses. The action requested, if you agree with that approach, would be motion A. I do have a slight tweak to motion A and would suggest, if you agree, that you should direct staff to proceed as recommended to reject the CMA comments as specified and accept CAPA's letter of support and provide the responses to the comments as indicated in the staff recommended responses. That would be my recommendation.
What page is that the recommendations are?
Page 8. And then if you don't agree and want to make any changes, then motion B would be your option.
No, I mean the date stamp number page.
I'm sorry, I don't have a bait number. Sorry.
59. Okay.
58. Starts at 58. Page 58.
Is it on? Yeah, okay. 58. Okay, Madam President, can I be heard on this?
Yes, you can.
Thank you. I still disagree with this because 3510 gives us the authority to implement regulations to carry out the purposes of Article 3. That is a very broad authority as I read it. I do not see anything that limits our ability to require immediate availability, which is different from presence. The legislature knows how to define those two differently, and they chose not to. But I think the letter that CMA proposed actually has an interesting solution to this. And that is, we don't require immediate availability, but simply place the onus on the doctor to say, hey, we want you to take the additional step of making sure by written documentation that the person is qualified. I don't think that is too big a stretch to do. Presumably, they're already doing that. If the doctors are already making sure that somebody can operate in a general anesthesia theater, I mean, we hope they're doing that. I mean, it'd be crazy not to, right? Why not just have them document it? That makes perfect sense. It provides an additional layer of protection to the public. And I don't think it's any great onus. If you've already done it as part of your practice to make sure that the persons are competent, why not just make sure that we state you have to make sure in writing that you're doing it? I don't think that's a big onus. I think it's a fair compromise. And it does fulfill our further goal, our most important goal
of protecting the public. Because Dion mentioned before, look, in a big hospital setting, I get it. You're probably not going to have any leakage of people that are not competent to do this in a hospital setting. Totally get that. LA, San Francisco, San Diego, not a problem. Truckee, Visalia, Coachella, Bishop, that may be a problem. And I think that's where we would see the leakage of potential damage. So I would suggest that we look at into incorporating that simple step. Again, it doesn't require immediate availability, which I think is a mistake, but I defer to the wisdom of my colleagues. But having the practice agreement include something that is presumably already being done is no great onus, I don't think.
May I be heard on that?
Yeah.
So thank you, Mr. Armington. I really appreciate your take on that. I would disagree. I think that that needs to be determined at the practice level. There are, as I mentioned in a previous board meeting, checks and balances in place, regardless of where you are, whether you're in Coachella or Bishop or here in larger metropolitan areas, where there are specific rules around PAs participating in an operating room theater and the amount of supervision required. I don't think that we need to be prescriptive as a board and arbitrating that practices put this in the practice agreement. So I do agree with Christie's interpretation that you cannot require the physical presence of a physician. I think the Senate Bill 697 clearly articulates that and is the legislative intent moving forward. I think that, you know, we are at the stage, ladies and gentlemen, where we are 2 months away from having to get this through the Office of Administrative Law. Any additions that we do now to the codified text could actually delay our ability to get a regulatory package over the finish line. And we are now almost 4 years out from the passing of Senate Bill 697, and we do not have a regulatory package to go along with it. Now, if you look at the advanced practice registered nurses, they have passed their bills and the regulatory packages with those bills, but the PAs have not. It is a disservice for us to continue, I think, to debate this. I think at the end of the day, the codified language is clear and meets the legislative intent of Senate Bill 697. And I agree that we should adopt option A as articulated by Christie.
Well, let me respond. I don't think it is improper for us to seek to protect the public. And what CMA is asking is not very onerous, and it is something presumably already being done. I can't imagine that it's not already being done. And the delay here, I would point out, is COPPA's fault. They agreed to the prior incarnation. We negotiated this a year ago. They agreed to saying, oh, okay, immediate supervision or immediate availability in a general anesthetic session, that's fine. Any delay is clearly their fault because they completely changed position. So I don't think it's unreasonable to go with the simple addition of, we're not asking anything extraordinary. We're just saying, hey, make sure the writing, don't just take the PA's word for it. Make sure you've assured that you reviewed whatever writings are necessary, educational certificates, whatever training they've done for general anesthetic. I don't think that's that unreasonable, especially if they've already done it, which presumably they have.
I'd just like to add, just as a reminder, historically, the regulations that we're currently operating under are ones that the board inherited from the medical board, who has authority to supervise physicians. And so this board was the committee of the medical board. And so the standards you see that are set for physicians and how to supervise were set by the medical board. Once the separation occurred and this board became independent, had its own rulemaking authority, we lost that kind of ability to set supervision standards for physicians. We had that remaining regulation that allowed us to do alternative mechanisms in concert with medical board, but they struck that from the bill. So my concern is that the Office of Administrative Law, regardless of what CAPA may or may not have agreed to, would look at it neutrally and objectively and say, where's your authority to set standards for physicians? and to require physicians to review documentation which indicates the physician assistant is trained and qualified to perform the surgical procedures under such anesthesia or sedation. I'm
that's their
having
point. That's their
concern.
point.
That's my concern, is that those legislative changes really fundamentally alter the way the regulations are adopted for this board, in my opinion. And if not, what was the purpose of SB 697 than to just change the title of delegation of services agreement to practice agreement? I mean, otherwise, that's the only change that happened. I'm not sure what other changes occurred.
I would agree with that. And just to underscore the point, and I think Juan here mentioned that, not to take the PA's word for it, but to really kind of do our due diligence. That is done by credentialing and privileging committees. I know because I sit on the interdisciplinary practice committee that reviews applications for PAs and nurse practitioners and other advanced practice providers in terms of their education and their training and their level of competence. That is already being done at the hospital level, at the systems level. So, I understand that we want to, put everything in this regulatory package, but it's really not needed because there are checks and balances. Most of these hospitals are Joint Commission accredited institutions. There is specific parameters and requirements for fact checking to ensure that the providers that are coming into your institution are competent to practice medicine and
Right.
participate in the OR. We don't need to be duplicative by putting extra language in the regulatory package that already exists at the systems level. So as a person who sits on an interdisciplinary practice committee, I review applications all the time, and it's my job, as well as the job of other committee members and other practice committees outside of us, to determine the training and experience and competency and whether or not that is sufficient for an individual to practice medicine at that said facility. So putting all of this additional language in the regulatory package is duplicative, in my viewpoint, not needed.
So I think Christie jumped over a big point here, and this is clearly in the letter. We're not asking to supervise or tell a physician what to do. We're simply saying the practice agreement must include verbiage that says, we've reviewed your writings. Now, Deanna's telling us here, we do that. So I don't see the big deal. And I get you guys are PAs and you do this at the practice level. I'm a member of the public. I'll tell you right now, I want to make sure that if a PA is going to be doing general on me, number one, I'd want to make sure, not a chance, that MD is going to be in the room for me. Okay. Barring that, I'd want immediate supervision. If we're going to say we're regulatory not going to be able to do that, I want to make sure as a member of the public that at least the MD that's supervising has reviewed the credentials of that PA. I don't think it's onerous. I don't see why this is such a big deal. Now, if we're going to land on, well, that's not the intent of the legislature. Okay, reasonable minds can differ because I agree that the statute is not as clearly drafted, and Christie and Michael will tell you that happens all the time. Statutes are not clear. That's why we have courts. If they were clear, we wouldn't need courts to tell us what they say. But that's my position on this. And I would make a motion to include the language of the CMA letter. And I hope somebody would second that.
May I be heard on this? So again, just to reiterate to the board members here, I understand Juan's concerns, but again, the system, the hospitals in which PAs are employed at already do these background checks. They do their due diligence. So it's not just the physician reviewing the credentials. It's actually the healthcare system or the hospital system reviewing the credentials on top of what the physician's reviewing. So we already have a robust structure in place that does due diligence of looking at applications and ensuring that the providers that come into healthcare facilities are competent, have the necessary training and skills to be in the operating room theater, either as a first assist at the bedside or playing some other role within the operating room. So I think it's very clear that the infrastructure is available, and I don't think that we need to put this regulatory language in the packet since this already exists at the systems level and has existed. And by the way, we have no evidence to support that putting this language in is actually going to protect the public any better than what currently exists.
I think we do.
We have
anecdotal
no
evidence.
empirical evidence to support that. We
I
don't.
think we do. I think we.
Are
have
there any
test.
questions or comments?
May I
Yes.
make a
Ruth.
comment? As a fellow public member, I do really understand your position. If I had a physician assistant performing, I would just want to know that everything possible has been done to ensure.
Okay, any other comment?
Just a quick question. In the hospital setting that Dion's mentioning, really all settings, does the agreement that the patient consent to include specifics, information that surgery care is being provided by Dr. XYZ and PA NYZ, whatever? Is that included in that document that the person signs and they're given informed consent?
Yeah, and it should be, because typically when you're doing the informed consent is with the operating surgeon. The operating surgeon is explaining the risks, benefits, and alternatives of the procedure. They may also explain that there would be a PA involved in the case, or a resident or a fellow involved in the case. Those are discussions that usually happen, as you know, between the physician and the patient. So there is, again, folks, a robust system in place. I know I keep reverberating this and reiterating this. I don't think that we need to include this regulatory text because, again, it's already been done. And I don't think the board has any authority here to, to Christie's point, to suggest to the PA and physician team things that are prescriptive and outside of the legislative intent of Senate Bill 697.
And with that, Christy, would you like to make a motion or?
Well,
I can't
Sorry,
make a
I'm sorry.
motion.
Sorry, Deanne, would you like to make a motion?
I would like to make a motion to adopt option A.
Well, wait a minute. Point of order.
As revised?
I
as
already
re-
made a motion.
Oh, did you make a motion?
Did
I
you make a
did.
motion? I didn't know you made a motion.
Yeah, I made a motion to adopt the language proposed by the CMA letter.
Okay, we're not on that item yet. We're just on the comments. So
Yeah.
what I'm asking for is a motion to accept the responses that I've drafted to the comments. And then we'll move to the text, which is this item B. We're on 11A right now, which is consideration of public comments received during the 15-day comment period. I know you've been discussing the text and the policy. That does weigh into the comment responses, but right now we're just doing item A, which is to accept or reject the comments. And what I'm
Well-
hearing from you is you want to accept some of CMA's comments and not reject them. So that's where I need a motion.
Well, point of order, Michael, I don't think we need to follow this set list of motions. I think we can make a separate motion, especially if it's going to be subsumed. The one motion subsumes the other.
I mean, we recommend that you use the motion language in that's been provided in the report. But certainly, I mean, a motion is in order at any time. Previously, I did not hear I thought I heard you discuss a motion.
Yeah.
But I didn't hear one come through.
Yeah.
But the normal procedure is once a motion is made, it can't continue to be discussed unless there's a second.
Correct.
So that's in that moment, the motion's on the floor and we need to ask for a second.
Well, right. I said I wish somebody would second it, and then we proceeded to other discussions without the call by the president for the second. So I had made a motion to adopt the language that CMA proposes, and I said, I hope somebody here would second it, and then that was not allowed. We continued other discussions.
Okay, so we didn't hear that, but my question is, so we need to accept a motion to accept the comments first.
Well, that's what I'm recommending, but the board's free to do what it likes, but.
No, I
maybe
think
later
if we can, I would like to follow exactly your instruction around that. Could you just read?
So
your-
the agenda, which was approved by the president, has 3 items under it. The first item is consideration of public comments received and proposed responses thereto.
Okay.
So what I'm asking is for a motion to accept or reject the proposed responses. And motion A with the amendment I suggested, because the recommendation would be to reject CMA's comments and accept Kappa's letter of support and provide the responses to the comments as indicated in the staff recommended
So
response.
I would like to make a motion to accept Kappa's letter of response to the comments and reject the California Medical Association's responses
Is there? a
As
second?
indicated in the staff.
as
recommended
indicated in the,
responses.
as indicated in
The
the,
recommended responses.
in the recommended responses.
Which page is that on in the pamphlet?
Page 58.
Is there a second?
I'll second.
Okay. All right. Is there any public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and it looks like we do have a request from Lucas Evenson. And Lucas, you'll be given 5 minutes to speak with a 30-second warning. Please click the unmute me button when the prompt appears on your device.
And I'm speaking on behalf of the California Medical Association. CMA continues to request the language in our letter be adopted and reject the recommendation by the board staff. We maintain our language is within the board's authority. Our proposals also align with the board's original intent when promulgating these regulations to place additional parameters around PAs performing surgical procedures without a physician present. Thank you.
All right, this is the moderator. Appears there are no further requests for public comment. Would you like me to close the Q&A panel?
A moderator, we didn't hear the comment.
Let me see if I can have Lucas speak again.
So can you hear me?
Yes.
Oh, okay. Hello, my name is Lucas Evanson, and I am speaking on behalf of the California Medical Association. CMA continues to request the language in our letter be adopted and reject the recommendation by the board staff. We maintain our language is within the board's authority, and our proposals also align with the board's original intent when promulgating these regulations to place additional parameters around PAs performing surgical procedures without a physician present. Thank you.
Thank you. Okay, Ms. Herr, would you perform a roll call vote, please?
Can you repeat the motion to this?
Do you want me to do it?
Yeah.
Okay, the motion was to direct staff to proceed as recommended to reject the CMA comments as specified and provide and accept Kappa's letter of support and provide the responses to the comments as indicated
That was the motion.
in the responses.
Was to accept Kappa's conference and reject the California Medical Association's comments.
Ms. Herr?
Charles Alexander,
Aye.
Juan Armenta,
No.
Sonia Early,
Aye.
Diego Insunza.
Aye.
Vasco Dianke,
Aye.
Deborah Snow.
No.
That concludes the votes.
Okay.
Does that
and
pass?
The motion passes.
Oh, motion passed.
Okay, and we'll move back.
So we're on to item B, which is consideration of adoption of amendments to CCR Title 16, Sections 1399.502, 1399.540, 1399.541, and 1399.545 to finalize the current rulemaking. So the motion is on, and again, I don't know the bait number, page 9 of the memo. Maybe it's 59. I'm not sure of the bait. I don't have the bait numbers. So if the board rejects the previously discussed comments and accepts Kappa's comments and makes no further changes to the proposed text, staff recommends the board consider the following motion to complete the rulemaking process and adopt the proposed text as set forth in attachment 1 to the meeting materials. Direct staff to take all steps necessary to complete the rulemaking process, including the filing of the final rulemaking package with the Office of Administrative Law. Authorize the executive officer to make any non-substantive changes to the proposed regulations in the rulemaking documents and adopt the amendments to 16 CCR sections 1399.502, 1399.540, 1399.541, and 1399.545 as noticed in the second modified text in attachment 1. If the board disagrees or has further changes to the text, please consider option B.
I would like to make a motion.
Uh,
I would like to make a motion. Oh, so moved.
Option A, you mean?
Yep, I so moved to option A.
Is there a second?
I'll second.
Excellent. All right. Do we have any public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests for public comment, would you like me to close the Q&A panel?
Yes, please. Excellent. Ms. Herr, would you perform a roll call vote?
Charles Alexander,
Aye.
Juan Armenta,
Aye.
Sonia Early,
Aye.
Diego Insunza,
Aye.
Vasco Dion Kid,
Aye.
Deborah Snow.
Aye.
Motion carries.
Okay, thank you. And then our last item is consideration of proposal to authorize initiation of a new rulemaking to amend CCR Title 16, Sections 1399.502, 1399.540, 1399.541, and 1399.545. Under Government Code Section 11346.4 Subdivision B, the board has 1 year from the date of the publication of the notice of proposed regulatory action to complete the rulemaking process. If the board fails to meet this deadline, the board must start over with a new filing if it would like to adopt regulations on this subject. The board began the rulemaking process for implementation of SB 697 on July 28, 2023, and has until Friday, July 26, 2024 to complete the rulemaking with the text approved above in Agenda Item 11B. The Office of Administrative Law has 30 working days to complete the rulemaking review of the rulemaking file and the proposed text. In the unfortunate event the board runs out of time, because in addition to the Office of Administrative Law, you have to receive approval from the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency, which can take 30 to 45 days. If that perchance doesn't happen in time for us to get the rulemaking reviewed and done through the Office of Administrative Law, staff are requesting that the board authorize the executive officer to start the process over with the text in attachment 5, which matches the text approved in attachment 1 in the required format for beginning the rulemaking process. If the board has no changes to the second modified text notice discussed in item 11B, staff requests the board move option A. And I can read it, but it's long.
So moved.
Yeah.
Awesome. All right. Are there any questions?
Do we need to make a motion on that one or we're good?
If you move option A, then it would just give us authority in case we run out of time to start the process over with the text where we ended at this meeting.
Okay. So then we would,
So moved.
yeah, so moved.
So if you want to move option A, and I can read it into record if you want,
Well,
it's up to you.
it's fairly lengthy, so.
It is long.
I'm okay with that.
Yeah,
Just,
I'm okay with that.
yeah.
Okay. You're okay, Michael? Okay.
Yeah, it's in the report. I think we're good.
Excellent. Is there a second?
I'll second.
Excellent. Is there any public comment?
This is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests for public comment, would you like me to close the Q&A panel?
Excellent. Thank you. Ms. Herr. I call for a roll call vote.
Charles Alexander,
Aye.
Juan Armenta, Sonia Early,
Aye.
Diego Insunza.
Aye.
Vasco Diankit,
Aye.
Deborah Snow.
Aye.
Motion carries. All right.
All right, thank you. I'll
Thank
turn it
you.
over to Ms. Dillon.
Thank you.
Thank you.
Okay, so now, Madam President, now I'd like to make the motion that looks like we're concluded with 11 to actually include the language in the CMA letter.
So item 11B was the second modified text, and this board approved moving the second modified text forward the way it was written previously. So I thought you had changed your mind and agreed to
No,
support it.
I was walked over my prior motion. I'd like to make the motion to have that language adopted.
Madam President, I don't think that motion is in order because the board just passed a motion that does the opposite. If someone who voted in the majority wants to make a motion for reconsideration for that would be in order. It has to be made by someone who voted in the minority on the main motion. No, in the majority.
Majority, yeah. I think they all voted for it, actually, so.
We all voted for it.
Exactly. So I'm making the motion to reconsider because I had made the motion previously, which was not given an opportunity to be second. And if it's not going to be seconded, fine, but I want to make the motion that we adopt the language that CMA has proposed.
So correct me if I'm wrong, Michael, but did they have to vote to reconsider their prior vote on the prior motion first to rescind it, and then they can make a new motion if it's rescinded?
Well,
I thought it's a
the
two-step
motion
process.
to reconsider the vote on that item, and then we will go back to the main motion as if it was back on the table. If that motion is defeated, then you could make a new motion for the changes.
Okay, so I'll move to reconsider that B, and I want to make it clear that the only problem we have is that we should include the CMA language that. What page is that on?
Well, there's a motion on the table. Is there a second? Otherwise, we can't continue to discuss the motion.
Don't think I'm gonna get anywhere. I'll second it.
Thank you.
So the motion would be to reconsider item 11B. And so that if you vote in favor of it, then you would take up the 11B item again. And at the beginning with the motion that started the discussion. If you vote against it, then your position is you don't want to reconsider it. Right, Mr. Knutz?
We just take a roll here just to.
Well, we
Is there
first
any
take public.
comment?
Well, first we do need to take discussion
Okay,
on the motion, member discussion, and then move to public comment.
member discussion.
Okay, so I want to make clear that all I'm suggesting is we reconsider to include 3 and 4. This is page 82 of the pamphlet. And I want everybody to notice very clearly what it says. That a practice agreement shall not authorize the general anesthesia we're talking about, unless the supervising physician reviews documentation indicates that the physician assistant is trained and qualified to perform that. So all we're asking them to do is that the practice agreement has to say, hey, we have to review and make sure the documentation is there, which we've heard now is already done. So this is not a big deal. And it just provides an additional level of protection to the public, in my opinion.
Have you heard on this?
Yes.
So again, just want to reiterate that this process is already being done. It's duplicative to put it or suggest that practice agreements should have this language when it is already being done by the physician, by the PA team, by the healthcare system where the PA is practicing. So there's a lot of checks and balances that are done to ensure that the PA has the level of competence, skills, and training needed to perform procedures in the operating room. And I just want to reiterate, there's a lot of other checks and balances that we're also not putting in the practice agreement, right? So we can't put everything in there, but I would just say that this level of due diligence is already being done by the healthcare system as part of their, their own consumer protection and ensuring that patients have providers that are qualified to treat their conditions. So I again reiterate to the board that we need to reject the California Medical Association's suggestion and continue with what our previous motion was, which was to accept Kappa's remarks regarding this issue.
So here's what I can't get my head around. We all know that general anesthesia is unique. You're out. You're completely under control of somebody else. This is not a setting of a bone. This is general anesthesia. This is momentous. This is a big deal. Things go wrong under general anesthesia. I can tell you that personally, from personal experience. When I was supposed to be under general anesthesia for an hour and was there for 11. Things go wrong. Okay. If this is already being done for this unique setting, what is the problem with simply putting it in writing that the practice agreement has to have it? I don't see the inconvenience. I don't see the disconnect. And if it provides the public an additional measure of safety, I just have not seen, Vasco, the connection or the disconnect where it says, okay, we're already doing it. So why don't we just say that that is a part of the requirement in order to allow this to happen? It seems like a no-brainer to me.
I guess I'm back to my legal arguments because it doesn't seem like you're addressing the issue that they repealed the regulations that allow this board and the medical board to set alternative mechanisms for supervision. And the fact that all the legislative history talks about this autonomy that you had, I know you had a concern with last time that we had met in March. And they talk about the fact that it's changing the way that regulations happen with the physician assistant board in the legislative history. And if you look at the language, that's exactly what they did. They repealed this board's regulatory authority to set alternative mechanisms for supervision and the medical boards. And then the only thing they restored was the ability of this board to require supervision, personal presence, physical presence, whatever you'd like to style it, in the event that there's a reinstatement, probation, or discipline because of a failure in supervision. So this tracks the advanced practice nurse scope, which is what they said they intended to do in the bill.
No, that's the best argument you have, right? That they removed supervision and then restored it, except in one limited circumstance. I agree.
Yes.
That is the best argument you have. This doesn't require supervision. This simply says that the practice agreement has to assure that you have reviewed the credentials. It doesn't say supervision. It
Where
just
does,
says review.
where
the
does it
credentials.
say in Business and Professions Code Section 3501 or 2 that that the board has the authority to require them to comply with its regulations on supervision as a condition of the PA performing that service?
In 3510, it says we can pass any regulation we want to assure the safety of the public.
It doesn't say that.
Of course it does. Read it. We have the input, we have the authority to write any regulation that implements the intent of this article.
Right, but the intent of the article was to allow the physician assistant to perform the, notwithstanding any other law, any service that's agreed to in a practice agreement under certain criteria, which are not set by this board, but by the legislature and in the practice agreement. So there's nothing in that list that says anything about and must comply with the board's regulations. They took that language out.
Right. That's SB 697. The entire article says that our primary duty is protection of the public.
Oh, I agree with that, but that doesn't mean we can create a regulation that's in conflict with the express purpose of the statute and the requirements the legislature set.
Yeah.
So when the legislature made a policy decision, they believed that there was enough public protection built into the system so that the physicians and the physician assistants could create practice agreements and set those standards because they're already in the system. And that's similar to other supervision with other practitioners in the department. We don't have, and you had a unique authority to set supervision standards and, and concerns, I think, that they raised about adequate care in the state of California, they removed it to allow for more growth in the area. And as CMA admits, the current regulatory structure was, in their view, burdensome. And so they felt like that it was easier to work with nurses than it was with PAs. And so they modeled this language after what the changes they had made in the Nursing Practice Act. And so that was some of the arguments the CAPA made for how that their profession was being limited more than nurses were being limited. And so that's one of the arguments they made. And when we were working through the legislature, we argued for retaining the supervision authority and for setting standards for how physicians work with PAs up front. And the legislature only allowed the board to retain its authority with respect to petitions for reinstatement, probation, and discipline. So that's where we ended up after I went through that whole opposition this board had to the bill back in 2019. I lived through that.
I totally get it. The problems continue to be CAPA first agreed with the immediate availability. And that's immediate availability is different language. It is different. Immediate availability is completely conceptually different from physically present. Those are two separate things. So that's where I think you have, again, the statute is, to me, is at best ambiguous in this respect. There are things that are perfectly clear in the statute, and those are easy, right? The clarity of the statute is, in other respects, pretty easy.
I think we have another comment from Michael.
Yeah, I just wanted to jump in. I'm looking at this from a little bit of a different perspective. When you look at the requirements for the practice agreement, which is section 3502.3, it begins, a practice agreement shall include provisions that address the following. A, the types of medical services a physician assistant is authorized to perform. So if they can perform anesthesia, that has to be in their practice agreement, and it has to be authorized by the physician. If the physician doesn't check, any competent supervising physician is going to be checking the qualifications of the PA to make sure they're qualified to perform that service. So I think that is covered already in 3502.3.
Excellent. And so now we're going to move to public comment.
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, it appears there are no requests on WebEx. Would you like me to close the Q&A feature?
Please, Ms. Hurd, would you like to call for a roll call vote?
Just
to make sure what the motion is.
Okay.
Just so we're
Let
clear.
me, yeah, so we're on a motion to reconsider. So it's sort of opposite. If you like the original motion and want that to stay the same, you should vote no. If you want to go back to that motion and revote or relook at that, then you should vote yes.
Is
Thank
it,
you.
excuse me, is it too late for me to make a comment? I agree with one that I wish it was in there, but I'm going to take your legal advice at this point that
So
it's covered.
Okay,
So
great.
Michael commented on A. I would point the members to B before you vote, which says another thing that has to be in the practice agreement are policies and procedures to ensure adequate physician assistant, including but not limited to appropriate communication, availability. So this is where I have the problem that the statute is ambiguous. It says the thing has to do with availability. So, but I don't want to belabor the point. I mean, I think we know which way this is going, but I think there is ambiguity here. And where there is ambiguity, my preference is to fall in favor of protection of the public.
Thank you so much. Ms. Hurd, can we call for the vote? Oh, yes, go ahead.
I'd like to just, we have a physician on this board who's a non-voting member. It'd be interesting to hear from the physician in terms of this discussion that we're having. I'm very interested in your opinion.
Well, I guess, thank you, Charles. Excuse me, I was coughing already. It wasn't that coughing. So, and I'm gonna split the baby in half because it really is accurate that it appears that there is adequate protection. But that doesn't mean that a member of the public may not have concerns. One question I did have was, are we talking about PAs functioning as anesthesiologists or PA functioning as surgeons doing a procedure? I think it's the latter. And so if it's the latter, you have an anesthesiologist who's watching, either nurse anesthetist or anesthesiologist who's watching what's going on with the patient. And we're talking about a physician assistant performing a procedure that a patient has already agreed to and knows that that person is involved in it. Now, we know that there's varying degrees of due diligence that patients do when they review those things that they sign. And we know, which amplifies the importance of having an advocate there who says, well, what does this really mean? Is my wife, my son, my brother, my husband at greater risk because this person with this training is performing versus another person? And so the bottom line is I think that I'm agreeing that it's duplicative. I understand the concerns related to transparency with patients and having an individual make a decision about that. I'm not sure that putting it in there because it's duplicative adds much to it. I don't think it adds much teeth. That's my comment.
Thank you, Dr.
Thank you. Any other comments? Okay, Ms. Hare, roll call vote, please.
Charles Alexander,
Aye.
So,
okay,
so just to make sure that we understand what the motion is. So I just want to make sure. So Juan's comment would be to include California Medical Association. So then,
Well, the motion is to reconsider your prior vote. If you like your prior vote, you vote no.
exactly.
If you don't like don't like it and want to
Sorry, I just
consider
had to stop there for a
Mr.
second.
Pimenta's comments and modify the text, then you vote yes.
So everyone who voted yes before would be voting no this time.
If they.
Well, if they want, I mean, it
Right,
just
meaning-
depends. They may have changed their mind
I
during the course of
understand
the
that. I
conversation.
understand that, but I'm
So-
just saying-
But I think the question is, do you agree with the prior action taken? If you do, you're going to vote no on this. If you don't, and you want to reconsider what happened previously, vote yes.
Okay.
I'll take my vote. No, but it's in Dr. Hopkins.
Okay. Okay.
Charles Alexander,
No.
Juan Armenta,
Yes.
Sonia Early,
No.
Diego Insunza,
No.
Vasco Diankid,
No.
Deborah Snow.
No.
Okay, motion passes. Thank you.
Fails.
I'm sorry, motion
Motion to reconsideration fails.
to reconsideration fails. Thank you.
Now we're back to where we were.
Previously.
Yes.
Awesome. All right, and with that, I think we will take a break. And so we will come back at 10:25. Excellent. I would like to call the meeting back to order, and it is now 10:28. Ms. Herr, will you call the roll?
Is this for,
Just to come back to.
oh, just to come back, okay.
Mhm.
Charles Alexander,
Present.
Juan Armenta, Sonia Early,
Present.
Diego Insunza,
Present.
Vasco Diankid,
Present.
Deborah Snow,
Present.
Randy Hawkins.
Here.
That
Excellent.
concludes roll call.
Thank you so much. We'll keep moving on to agenda item number 12, where we have regulations and the update on pending regulatory package by Ms. Dillon.
Starting. Can you hear me?
Yes.
Starting with the first package, SB 697, license renewal and continuing medical education required. At the November 6, 2023 meeting, the board voted to adopt the revised regulatory language, and staff is currently working on initial documents with Regulations Council and the Budget Office to submit for initial review. The next package, SB 697, implementation. At the March 4th, 2024 board meeting, the board approved the second modified text and adopted the revised regulatory language in response to the comments received. A second 15-day public comment period on the second modified text began on March 7th, 2024 and ended on March 22nd, 2024, and the board received 2 comment letters. Board staff is requesting that the board review the submitted comments and propose board responses to those comments. Staff and Regulations Council recommended the board approve the following proposed responses to the comments. In the next package, SB 697, application exam scores, addresses, and record keeping. At the November 6, 2023 meeting, the board approved the proposed regulatory language to reinitiate the rulemaking process. Staff is currently finalizing initial documents with Regulations Council and the Budget Office to submit for initial review in June of 2024. The next package, titled Retired Status to include fingerprint requirement. Staff will begin working on the initial documents to submit for initial review this calendar year. And finally, the final package, SB 1441, implement uniform standards related to substance abusing licensees and update of disciplinary guidelines. Staff is working on the proposed language for board approval in the next few months. And that concludes our update.
Excellent. Thank you, Ms. Dillon. Do we have any questions or comments from the board? Okay, I don't think we need to vote on any of that information, but thank you so much for that report. And we will move on to item number 13, where we have discussion regarding the physician assistant supervision ratio requirements by Vice President Kidd.
Sorry, President Hurley, can I make a brief comment?
Sure.
It's just a reminder that in my president's, my comments, I just want to remind folks on this Friday, May 24th at 9 a.m., there'll be a presentation on successful elements of a physician health program with 2 subject area experts at the medical board, since we just talked about substance abusing physicians and this and that. I just would encourage there be some representation, whether online or whether at the meeting at the accountancy board. Thank you.
Excellent. Thank you. Any questions for Dr. Hawkins or? Okay, moving on to item number 13, discussion regarding physician assistant supervision ratio requirements by Vice President Kidd.
So much, President Early. Thank you so much, President Early. Dear board members, I'm looking forward to a comprehensive and robust conversation on the topic of physician to PA supervision ratio requirement in California. By way of introduction, Business Profession Codes 3516 Item B stipulates that a physician and surgeon shall not supervise more than 4 PAs at any one time. So simultaneous supervision. The law addresses those PAs who are prescribers, so not those who are doing wellness visits or home health assessments where the requirement is actually 1 to 8. But for those that are prescribing and providing direct patient care, and this law has been in effect, as I mentioned, since 2008. So it's a 16-year-old law. During the COVID-19 pandemic, the director of the Department of Consumer Affairs suspended this requirement in order to improve access to the healthcare system. And so they suspended that requirement, and the first suspension took place on 3/30 of 2020, and the suspension was rescinded on February 28 of 2023. So it was nearly 3 years that the requirement that a physician shall not supervise more than 4 physician assistants during the public health emergency. And I think that's interesting, right? Because for the last 3 years, up until the time that it was rescinded, there was no ratio requirement. So physicians could determine the adequate number of PAs they can supervise at any one time. Now, interesting enough, I did a state-by-state analysis looking at states that have PA supervision requirements and those that do not. Currently, 20 states have no PA supervision ratio requirement. In fact, those states leave it up to the physician at the practice level to determine the number of PAs they can adequately and competently supervise. 29 states that do have supervision ratio requirements, 45% of those states in the last 7 years have increased the number of PAs a single physician may supervise or collaborate with at any one time. As an example, Florida, which has a population of 22 million people, according to population statistics, increased their PA physician ratio from 1 to 4, which is what California's is, to 1 to 10. Washington, which has a population of 7.7 million people, according to 22 statistics, increased the number of PA physician to PA ratio from 1 to 4, again, which is what California's is, to 1 to 10, with the ability for physicians within the state to petition to waive out of this requirement to even hire more PAs to supervise if they wish. And so is there any data to really support PA supervision ratio requirements? There is no specific guidance or best practices regarding PA supervision ratios in the peer-reviewed published literature, to my knowledge. There is no large empirical study that indicates the value of legislated PA ratios in improving clinical outcomes or quality of care. There are no empirical studies indicating that removing physician to PA supervision ratios negatively impacts physician practices or patient care, which is why 20 states have no requirement whatsoever. And those that do have a requirement have increased the number of PAs that a supervising physician can supervise at any time because they leave it to the practice level. And just to throw a little bit more skin on this, 90% of states allow for practice level determinations. So scope of practice is determined at the practice level in over 90% of the states. Now, why is this really important? Because California needs 8,000 primary care providers between 2025 and 2030, according to Force Center at UCSF data. In California, as an example, the state is only meeting about 50% of its primary care needs, according to Kaiser Family Foundation. It is estimated that up to 75% of primary care services could be provided by NPs and physician assistants, according to a report from the California Future Healthcare Workforce Commission. Additionally, California has a large component of physicians who will reach retirement age during the next decade, and there simply isn't enough medical graduates to backfill those positions. So as we kind of dive into this as a team, I wanted to talk a little bit about specifically questions that I have regarding some of this research. And this is a high level. There's actually more data that I could provide if anyone is interested. But essentially, in light of California's crippling shortage of primary care providers, which, by the way, is well published, everyone knows that we have a crippling shortage of primary care providers, not only in California, but across the country. So in light of the shortage of primary care providers and the state's inability to meet its primary care obligations, how does maintaining the 1 to 4 physician to PA supervision ratio improve access to primary care services? I would love for someone to answer that question for me so I can help to connect the dots. And then the second question that I have is, why shouldn't physicians be allowed to determine the number of PAs they can adequately supervise at the practice level like they can in 20 other states? I'm not aware of any evidence in the peer-reviewed literature to substantiate that physicians are not qualified to determine the number of PAs they can adequately and competently supervise at any one time. I look forward to a robust discussion on this issue. Thank you.
Any questions or comments?
What is this section about for?
3516.
Hawkins.
Hawkins.
Yeah, so just some comments. So the motivation, which I understand, which is to have more primary care providers, because there's a primary care provider shortage in the state of California, nationally and internationally for that matter. It would be valuable to have some of the answers to the questions that Dion said we don't have. And he mentioned several things. One of the reasons why there is potentially a problem with the decision at the practice level is that we don't know the motivation of the practice. So some people are highly motivated because they make more money. And it's okay that folks make more money if there's a corollary to that of providing really quality of care. So that's one thing. So when you give those statistics in those 29 states or 20 states that have no limit on the number of supervised, what type of practices are they? Large group practices or individual practices and that sort of stuff. So that's just one of the things I'd like to ask about. There are also, and it's been flip-flopping, but when I attended the match for physicians graduating from medical school recently at Charles University and UCLA, a significant percentage of them were going to subspecialties. They weren't going into primary care. So my other question is, what's happening with the trajectory of PAs who are graduating? Are they going to primary care? Are they going into primary predominantly subspecialties? And that'd be just the beginning of what I would just to start the conversation about this area.
So Dr. Hawkins, I am so glad we have a physician on this board. And so thank you for your insight on this issue. So in the 20 states, there is no requirement for a PA supervision ratio at all. That is determined at the practice level. There are various motivations, as you mentioned. I think the primary motivation of the states that removed it was to increase access to primary care services and other services where there is scarcity of providers. And you know, we have a 16-year-old requirement. 16 years we've had a 1-to-4 ratio at the same time that the state is grappling with a manpower shortage of providers, especially in areas of critical need. Brown and Black communities suffer from a lack of access to care. That's well documented within the literature. And yet we have a 1-to-4 ratio requirement where 20 other states have gotten rid of that ratio requirements, and the other 29 that have ratio requirements have made improvements. 45% of the 29 have made improvements to their ratio requirements. I don't see a downside risk with allowing a physician who we trust them with medical decisions and surgical consultations and with other things that benefit, you know, patient care and access. How come we don't trust them with this decision to make a determination at the practice level on the number of PAs they can adequately and competently supervise? I have yet to find anything in the published literature to substantiate why we even have PA supervision ratios. They're not tied to any clinical outcomes that I can glean from the literature. And that's the challenge.
So just another question. I forgot to mention something else. So if it's possible that physicians may not have to review medical records percentage like they had to do in the past, I wonder in any of those states, whether it's 4, 12, or unlimited number of physician assistants supervision by physicians, do we have metrics on, I think you said no, discipline, quality of care metrics? Do we have that kind of information that helps us feel more comfortable about the numbers don't matter?
No, we do not. I don't have any data on that, but I would tell you this, that the states that have removed the ratio requirement have not reinstated it. And I think that says a whole lot. So in 2008, there were 10 states in 2008 that had no ratio requirements. In 2017, 2 more states joined the fray for a total of 12. And from 2017 to 2024, another 8 states removed the ratio requirement. So if you look at from 2008 to 2024, that's how we arrived at the 20 states. So some of these states have not had ratio requirements for over 2 decades. And so I think if there were issues regarding disciplinary issues or adverse outcomes that other states would have viewed or looked at data from these other states that had no ratio requirement, and probably said, well, this is probably not the direction we want to go. But the fact that we see 20 states that no longer have racial requirements, and I just would want to point out that for nearly 3 years, we've suspended that requirement here in California, and the board received no concerns and received no complaints from the public. So we had so we beta tested the idea here in California during the public health emergency. And we didn't, and the medical board, and I would ask you for your advice on, but I don't think the medical board received any complaints for physicians supervising more than 4 PAs during the public health emergency. At least it wasn't brought before the PAB's attention for review. So given that, we've beta tested the idea here within our own state. And then when the public health emergency was over, we went back to a 1-to-4 requirement. I just, in my heart of hearts, have a hard time understanding why we have a 1-to-4 ratio when we have a primary care crisis where we're not even meeting our primary care obligations. And this was the same argument that the nurse practitioners made when now they have achieved full practice authority within the state. And so now they have the ability as a 103 or a 104 NP, and they're not subject to these ratio requirements because they're practicing independent of physician supervision.
So I don't want to hog the mic. So my last comment would be, just because we don't have data that's presented doesn't mean we should assume that there isn't more discipline. I understand about California, but I don't think we should necessarily assume that there's no problem with unsupervised and no limit on supervised PAs, no, so we diminish out of hand that there is motivations beyond quality care.
I do want to provide some anecdotal information. You mentioned, you went to the ceremony for match day. Working at a medical school, one of my students that was graduating, I asked what specialty he was going to go into or what he's going to do afterward. He says, "My love is primary care, but I can't afford to go into primary care." And so we find that a lot of our students opt out to other specialties because of the, I guess, pay difference. So and we were talking about primary care issues and access to care. That is a huge deficit and adds to our manpower shortage and workforce deficit. So anyway, there was some anecdotal information to that.
Yeah, and just to add on to that, I just think at the end of the day, when we're looking at access to care, we have to look at all of our resources available and figure out how we can leverage those resources for the betterment of the patient. How do we increase access? I mean, if 1 to 4 increases access so that we meet our primary care obligations, then I think people would say, well, Dion, there's not much of an argument because we're meeting our primary care obligations, but the state is only meeting less than half or right around half of its primary care obligations. That leads to worsening of outcomes. That leads to premature death. It leads to issues with, mortality issues and prenatal issues and other things that people are trying to get access in order to try to fix. So I think ultimately, the whole reason for bringing this discussion up is the whole purpose, I think, or one of the purposes of Senate Bill 697 was to look at these outdated ratios. I'm not sure why it never got addressed. And I think there is potentially an opportunity to address it. And maybe we just need to have more discussion and we need to look at more data. But I can just tell you that 20 other states have removed the requirement, which is a trend because from 2017 to 2024, states are taking action in order to improve access to healthcare services, whether it is removing the ratio requirement or it is increasing the number of PAs that a physician can supervise at any one time. What they're not doing is laying dormant on the issue for 16 years, which is what we've done here in California.
Can I make a comment?
Yes, please.
Could we, or maybe I can find out later which 20 states?
I have it for you.
Oh, okay, totally removed it.
Yeah.
And I really think it's a good idea to at least up the ratio, but I would like to see more data regarding discipline in other states.
Can I comment on that? So I feel like I've been teleported over to the Capitol because this is a policy decision that the legislature's already laid down. We talked about legislative intent earlier in our discussion about thing. The legislative intent here is absolutely crystal clear. This statute, and I'll explain why, isn't 16 years old. It's 1 year old. So anytime you amend a statute, it is presumed as a matter of statutory construction that the legislature in amending it knows what the rest of it says. And if they didn't change the rest of it, they meant that's what we mean. So when they amended this in 2023, it says, no, we mean 4. Now, the problem we have is that we're ill-equipped to address those policy decisions because we don't have the data, right? We don't know how many states, you do, 20, right? But we don't have the data underlying that, right? What practice, as Dr. Hawkins pointed out, what practice areas are they in? What is their disciplinary response? What problems have they encountered? All of those things are the sausage making that goes on just down the street over here at Capitol Hill, where they do have the resources to send out their staffers to go, if somebody wants to sponsor a bill, whoever it is, I guess COPPA in this case, they would have to assemble all that data. And, fortunately for us, that's not our job, right? We don't have the staff to do that. We don't have necessary to do that. I appreciate the concerns. I bet you, I will guarantee you that in the process of 697, COPPA made the argument already that, hey, why should we limit it to 4? Guarantee you they did. Okay.
They did.
See, I wasn't even there.
Yeah.
And I can tell you they absolutely did, because at the bottom end of the day, it's not just about provision of care. It's about an economic model as well. Let's not be naive on that. So the fact that they presented that and the legislature said no, and said it again in 23, no, it's going to be 4, really signals legislative intent. I think it's an interesting discussion. I think, you know, COP or whoever it is needs to, if they want to persuade the legislature, they need to go get the data and show the government. But you know, other than having a discussion, I don't know what useful role we can play.
Well, go ahead.
All I wanted to suggest is perhaps the board could have a task force to help you look into it more.
Yeah.
Oh, how are we going to pay for that?
I'd help free.
Yeah.
Oh, well, if you
I
want to do it
mean,
for free. yeah.
I'm not as experienced as you are, but
I think that's a great idea. And let me just say this, I think it's so important, right? So it is 16 years old. It is not 1 year old. It is 16 years old. So the 1-to-4 ratio came into light in 2008 under Assembly Bill 3. Prior to that, it was 1-to-2. So it was 1-to-2 prior to 2008. And then Assembly Bill 3 came in. And so in 2008, we went from 1-to-4. So that's been a kind of one size fits all 1-to-4 ratio requirement for hospital-based PAs and outpatient PAs that are prescribers and providing direct patient care. And that's been since 2008. And the point of this discussion, ladies and gentlemen, is that other states are moving in the direction to either remove the ratio requirement or to address it in order to improve access to care. And I think it's important for us to think about, as a board, how we could increase flexibility to the PA and physician teams, which is the legislative intent of Senate Bill 697, to provide the bandwidth that practices need in order to meet primary care concerns, especially in rural areas where there's limited healthcare providers. That is documented well within the state. And again, the nurse practitioners have already done this to getting their bills passed, and they use similar arguments, which is we have a provider gap, and nurse practitioners have passed a bill in order to address that provider gap. PAs still have a very structured and rigid ratio that has not been changed in 16 years. So what do the other states know that we don't know here in California? We all have similar issues, and I understand there's regional differences between states and challenges between states. But at the end of the day, I think there's an opportunity to improve access to care. Patients deserve that. And I think as a board, we have an opportunity to look at this as part of our public mandate.
Other questions, comments?
It's a good argument. It's a good argument. I'm one to see the data as well. I think I'm wondering behind the motivation behind some of the states for doing this. I mean, I understand the economic reason. I'm also concerned about the number of PAs that actually we begin to see schools now shutting down programs, and do we have the capacity to increase it? And also, given the size of the state, you know, would that mean people start gravitating towards certain parts of the state versus others for the economic reasons? There's no guarantee PAs are going to go into primary care, just like physicians don't go into primary care. And a lot of it has to do with you know, the salary, the income. The other question I have too is about physician management in terms of if you get more, do you have to manage more? Do you have time to manage more? And what does that look like? You know, not to say that it can't be done, but what does it look like, you know, for a physician to be able to keep track and to manage the number of PAs? But I do see the need in terms of access, but my concern is like, there's no guarantee that the PAs are going to go in the primary care unless you put some stipulation, you know, in there, or some incentives like they do for physicians, you know, where you give them loan repayment or you give them some preferable perk or something to make sure or to ensure that they do. And if they do, how long will they do it? And will they be able to survive and make a decent living, particularly given like I said, the size of this state and where people are going to go. But again, it's a good argument. I hear what you're saying.
I would be really interested in increasing it because I know there's a desperate shortage of medical care, but I would like to see more statistics. And I don't know if I should say this, I don't know if all states governing boards are as diligent as California. So I mean, I'm sorry, but
It is true. It is true.
okay.
I think we
So-
all know that, yes.
That's why I would like to know more about which states and
Sure.
so forth and actual discipline levels. But I think it is a great idea to
So,
increase it.
I'm sorry. Bree.
Excellent.
I'm done.
Oh,
I'm sorry.
Oh, sorry, Deb. Yeah, again, I think I'm back on the Capitol. So these are exactly the questions that would be put to the Capitol for the legislature to vote on. And here's what we're left with right now. Again, we talk about legislative intent. They made it clear, and I'm sorry, Vasco, it's not, the number is 16 years old, but the intent is 1 year old because they amended it and they had an opportunity to say, I mean, it's square in their face, right? We had a pandemic. We suspended limits. Now we're out of the pandemic. We're going to go back to, it was right on their plate. They could-
Are we out of the pandemic? No.
Well, we don't have emergency orders.
Right.
So they had it squarely on their plate to address it. And they said, no, we're staying at 4. So these are all great arguments. I agree. Access to care is critical. But our hands are tied. We have a legislative mandate that says specifically 4. So I don't know that there's anything that we can do. And so one thing I certainly don't want to do is burden our staff and our budget with going out and gathering data because this is a mountain of data to go get. It is a huge exercise. And if anybody's been involved in writing legislation that needs empirical data support, that's millions of dollars of budget of staffers to go do this stuff.
So there is a potential opportunity, maybe during the sunset process, where we could revisit this with the legislature. And I think it doesn't require the resources or the money in order to do that. I've done already a lot of the preliminary work, which I will be making available to the board members and be sending you something one by one. I can't say more of that because I have some really good opportunities to share the data more broadly. And so I'll know within the next couple of days, but I will make sure that I get the analysis out to you folks. So you can take a look at it. But I do think there is some opportunity during the sunset process to revisit this discussion. And, I think at the end of the day, it's worth revisiting given the crippling shortage of primary care providers that we currently have in the state. And I don't see any potential downside risk. I do understand.
I do.
Juan's comment, and I might be skating on thin ice here, but I'm willing to go to bat for patients each and every day, no matter what. And so
I
that's
see a big risk.
That's my gestalt.
I see.
Dr. Alexander?
I was just gonna say, there's probably some research centers out there that could do what you're asking to do.
Yeah.
Particularly UCSF, which is really deep into
Right.
Yeah.
doing analysis and help.
And some of the data that I got is from UCSF. So great point.
Excellent.
I see a big risk. And I just want to point that out so everybody is clear on this when we discuss it again in the future. When we come to the sunset and the legislature decides whether we should continue to exist or not, if they see us intruding onto legislative intent, that is clearly their bailiwick and which they guard jealously, I can assure you, they may say, you know what? We don't really need you guys. I think that's a risk.
I'm not sure I agree with that, but I think at the end of the day, I think, certainly, I don't think there's any downside risk with revisiting the language, and certainly we'll look at, meet with council and the executive director to see what our options are and what is in the best interest of the board. Certainly, I'm not the lone ranger here or lone wolf to make that decision. That is a decision for the board, but I don't think we can be afraid of potential downside risks when we're looking at trying to improve access to care, which I believe is a part of our regulatory function, right? There's 3 pillars to what we do that help us to fulfill our public mandate, which is licensing, disciplinary, and regulatory. And I do feel this falls under regulatory. And how do we know that? Because we just got finished approving the regulatory package, all right? So to me, this would coincide with that, autopsy of this particular code section to see whether or not there might be changes to improve access to care. And I think it's a good opportunity for us to revisit that. So, we'll see.
I appreciate the lively discussion. I just want to add one additional comment. I want to make sure that we know that PAs were created out of a manpower shortage. So when we go 60 years past when we were created, we still have access to care issues and we still have manpower issues. So I do think it's critical for us to discuss and think about and possibly, move forward in any way possible, whether we are here or not. It's our due diligence to do a great job in terms of creating or making sure that we don't have continued manpower issues. And with California being 50% below what we need, we have to think about, increasing those numbers in primary care, and then also improving our access to care. And that's why we're here, and that's why we were created. So with that, do we have any other comments? All right. Moving forward, do we have any public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests for public comment, would you like me to close the Q&A panel?
Yes, please. Thank you, Madam Moderator. All right, it appears that we're moving at a nice steady pace, and so we'll continue on, and thank you so much. Let's proceed to item number, and again, thank you so much, Vice President Kidd, for bringing that lively discussion, and thank you so much for everybody commenting on that information. And now let's move to item number 14, and that is Education Workforce Development Advisory Committee and an update on physician assistant education programs and applicants in California, and that's Doctors Alexander and Kidd.
Thank you. I want to mention, or at least preface the report by saying there's been some significant changes to this report, but it was sent in prior to that change. So I'm going to have Dr. Kidd talk a little bit about that. But as you can see in the report, there are 306 accredited programs, there's 21 in California. You can see the number on probation, the provisionally accredited, and those that are continuing to develop. And the majority of those programs, as you can see also, is in the Southern California area, where there's 15 and 4 in the Bay Area. You notice the highlighted yellows where it says probation on those lists. Those particular programs are going through varying types of probationary situations. And again, Dr. Kidd, he'll elaborate on those, particularly 2 that we know of on this list. Given the current argument we just heard, you could see the capacity is at 941, but that could soon change. But also in terms of the dispersal of these PAs going to different parts of the state, and whether or not, the increased ratio would help or not is another question to consider. And then, of course, the map that you see on the second page, I think it is, kind of highlights a little bit better where these programs are located in terms of the numbers and so forth. But all in all, I mean, we're steady right now, but like I mentioned, there's been some significant changes since the time this report was submitted. So I'm going to defer to Dr. Kidd if you could kind of elaborate more on what we're talking about today. So,
thank you, Dr. Alexander, and I appreciate your leadership on this committee, and thank you for the report on this. And as Dr. Alexander mentioned, there has been some considerable changes. The University of La Verne's PA program has voluntarily withdrawn accreditation. They had enrolled 24 students per cohort, and unfortunately, they will be closing their program. So their second-year students who have completed their clinical rotations will be eligible to take the Physician Assistant National Certification exam. However, their first-year students that are just completing their didactics will have to find other programs in order to complete their PA training. Remember, this is similar to Cal State University, Monterey Bay, which also was in the same predicament. And last that I've heard, or at least looked at their website, they've placed the majority of their students in other PA programs. And that is not an easy task to do because there's a finite number of seats in any PA program. And so to get an expansion of seats within a program to absorb another program's students is very difficult and sometimes not allowed if you don't have the appropriate resources, such as the clinical sites, and other resources in order to train up, these PAs. So this is huge because this is a largely Hispanic serving institution. And so this program will be closing, and this will create a further deficit in the number of PAs that we're graduating per year. In the last review cycle, that your accreditation, the ARCPA, which is the accreditor for entry-level PA programs, there were quite a few programs that were placed on probation, actually a large number of PA programs that were placed on probation, not necessarily in the state of California, but across the country. And what we keep continuing to see is that programs are having trouble meeting and complying with the accreditation standards, which are very voluminous in nature when you look at the number of accreditation standards. And two accreditation standards in particular stand out. B306, which is a standard, and it basically says, supervised clinical practice experiences occur with physicians who are specialty board certified in their area of instruction, or having a sufficient number of NCCPA certified PAs or other licensed healthcare providers to really help in the training of PAs. And so programs continue to struggle with clinical site acquisition and ensuring that they have a number of qualified providers to help train PAs. The other standard, which is not necessarily new to the PA profession, but seems to be somewhat of a challenge, is C103, which deals with the self-study report and the program's ability to demonstrate that they can conduct an ongoing self-assessment, which programs struggle with. It really takes a lot of analyses and critical analyses, and programs struggle with their self-study reports, which oftentimes may lead to an adverse accreditation decision. So, there are some challenges across the country, but here in California this year, we've had two programs that are now going to close. Cal State University Monterey Bay, which closed this month in May, and then the University of La Verne that I mentioned earlier, which has withdrawn accreditation. So they will be closing. So again, we're going to be producing less PAs until some of the new developing programs are up and going. And that would end my comments on the report. Thank you, Dr. Alexander.
Thank you, Dr. Kidd.
Any-
President Early, that concludes our report.
Excellent. Do you have anybody have any questions?
Just a quick question on University of La Verne. I don't know about the other school, but the University of La Verne, you said those second-year students, those in their second year will be eligible for taking the exam, licensing certifying exam. Is there a reason to suspect, based on the two major types of deficiencies, that they'll be at a disadvantage in taking and passing that exam? I don't know if that's knowable. I'm just curious.
Great question. No, there are, believe it or not, I find it interesting. That's a great question. There are programs that have been closed when their graduates have had over a 95% pass rate. So the pass rate in of itself does not mean that the program is healthy or is meeting the ARCPA accreditation requirements. Oftentimes we look at programs' health based on external benchmark scoring, right, to see how people do on the board exam. But if you're not doing the ongoing self-assessment and it's not in your self-study report, then that could lead to an adverse accreditation decision. So we have seen students do extremely well on the PANCE, but yet the program still suffers because they're not meeting or complying with accreditation standards.
So thanks for that. And so this is quite reassuring that we have entities whose task is to make sure that institutions are meeting the requirements to produce well-trained, ethical, and other criteria that we want in PAs that are going to be serving the public of California. So,
Any other questions? Great questions. All right, any questions or comments from WebEx, from the public?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. All right, and seeing no requests for public comment, would you like me to close that Q&A panel?
Please. All right, thank you so much, Dr. Kidd and Alexander. We're going to move on to item number 15. That's report by the legislative specialist, legislative update by Ms. Dillon.
All right, I'll be beginning with the AB 2194. This bill was introduced on February 7th, 2024, and is located in the Assembly. This bill was amended on April 24th, 2024. And this bill would revise physician assistant supervision provisions to authorize a physician assistant performing medical services under the supervision of a physician and surgeon, excuse me, to assist a doctor of podiatric medicine who is on the staff of the same organized healthcare system or who is a partner, shareholder, or employee in the same partnership group or professional corporation as a supervising physician and surgeon pursuant to a practice agreement. The bill would delete both the restriction requiring that a physician assistant who assists a doctor of podiatric medicine do so only according to patient-specific orders from a supervising physician and surgeon, and the requirement that a supervising physician and surgeon be available to the physician assistant for consultation when assistance is rendered to a doctor of podiatric medicine. In regards to fiscal impact, the board would need to provide an update of the supervision requirements on the board's website for licensees. This is something that can be done by staff and is supported by the board's current pro rata cost to DCA. And for board position, at its March 4th, 2024 meeting, the board took an opposed position, and that letter to the legislature is attached in attachment 1 for your reference.
Excellent.
So I have a quick question on that. So just looking at the new amended language. Disagreement with the PA, is that correct?
Yes, that is correct.
Okay. And then number 2, it seems that the amendments that were made were to remove the patient-specific protocol,
Yes.
right? That's really the only change that I see here, the patient-specific protocol, which would then, and I can understand that, right? Because Senate Bill 697 doesn't require protocols. But my concern with that is that if you remove the patient-specific protocol, then the PA may interpret that the podiatrist is their supervising physician and may list the supervising physician, right? Because we have a patient-specific protocol, it's coming from an allelopathic or an osteopathic physician. And then that patient-specific protocol outlines the conditions and requirements for you to be able to assist a podiatrist. And so my concern is by removing that language, then PAs would automatically think, and again, I'm generalizing here, but they may think that a podiatrist can now be my supervising physician. And so I think it takes away that requirement, which I think still needs to be embedded so that PAs understand that their supervising physician is either an allelopathic or an osteopathic physician. And by taking away the requirement, this may cause some confusion among some of the rank and file, which could potentially be a rabbit hole for them. So for that reason, I remain opposed to this legislation.
And I believe we all remain opposed to this legislation. So, excellent. Any other comments? Excellent. You can proceed.
So should we, are we taking?
I think we're going to do it at the end.
Do it at the end? Okay.
Mhm.
Okay, moving on to AB 2270, Healing Arts Continuing Education, Menopausal, Mental, or Physical Health. This bill was introduced on February 8th, 2024, and is located in the Senate. Current law establishes continuing education requirements for all of the various healing arts practitioners, and this bill would require the above specified boards in determining their continuing education requirements to consider including a course in menopausal, mental, or physical health. And in regards to fiscal impact, staff does not anticipate any fiscal impact.
Sorry, I might be monopolizing too much of my time at the expense of other board members, and my apologies if I'm doing that. So I still am having a hard time grasping why this legislation is needed, because PAs have the ability to take these CMEs. They're typically online for free. I'm not sure why we would need to have specific legislation around that, because that's available now for any PA.
Right.
That wants to learn a little bit more about menopausal, mental, or physical health. That's available. And the good thing is that most PAs do a variety of different CME in order to meet their licensing requirements and also to meet their certification requirements. So I don't see why we would need to legislate, or I don't know. I'm having a hard time understanding why this is needed, given that PAs have full reign to do this now if they choose.
I mean, I think we all agree, and I think at this time, we can make sure that we can go through our options, like either take a position, either watch and wait, oppose, support, or, say yes at this time. Is that correct?
Yes, certainly if the board wants to take a position on this legislation, I mean, a motion
Right.
is appropriate to take one of those options,
Okay.
oppose, support.
Okay. All right. So at this point, do we have any other questions?
Just briefly, Med Board did not see the benefit of this legislation directing CME courses, et cetera.
Yes.
Yeah, and also, if I could, I think this just says we are to consider. Okay, well,
Right.
it really doesn't do anything then. So
Right. Right.
we've considered it. Thank you.
Yes. 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 Excellent. Yes, we are considering not to support this bill.
Yeah,
So,
I would suggest we consider to oppose it.
Yes.
Is that what we should consider?
Yes.
And should we also do the same for the prior bill that we just discussed?
So for the prior bill, we already did that last time.
So we-
So what we can do is, we can talk about it, discuss it, and then at the end, I could do one vote. But right now, for AB 2194, we already opposed that, last, meeting. We will continue with that. And then, so for B, AB 2270, do we need to take a vote at this point? Or can we just?
If you want to. Yes, if the board wants to take a position, a motion to support the bill or oppose the bill, or
Okay.
or there's some other options there would be in order. And I'd suggest you do it now with
Okay.
the, if that's going to occur, I'd suggest to do it now.
Individually,
with,
okay.
in concert with the description of the bill.
Okay.
Well, then can I make a motion, Madam
You sure
President?
can.
I would make a motion to oppose this bill, as I don't see the utility of it. since it's
All right. Is there a
telling
second?
us to consider it.
And I'll second that.
Excellent. And do we have any public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. All right, and seeing no requests for public comment, would you like me to close the Q&A panel?
Yes, please. And Ms. Herr, would you call for a roll call vote?
Charles Alexander,
Aye.
Juan Armenta,
Aye.
Sonia Early,
Aye.
Diego Inzunza,
Aye.
Vasco Dianke,
Aye.
Deborah Snow.
Aye.
Okay, motion carries to oppose this legislation. Awesome. All right, so item number C.
All right, moving on to AB 2442, Healing Arts Expedited Licensure Process, Gender Affirming Healthcare and Gender Affirming Mental Health Care. This bill was introduced on February 13th, 2024, and is located in the Assembly. This bill would require boards to expedite the licensure process for an applicant who demonstrates that they intend to provide gender affirming healthcare and gender affirming mental health care as defined within the scope of practice of their license, and would specify the manner in which the applicant would be required to demonstrate their intent. This bill would repeal its provisions on January 1st, 2029. And in regards to fiscal impact, this bill would require staff to update the board's licensing process to ensure applicants who meet the gender affirming health care and gender affirming mental health care criteria can get their license application expedited. This would require the license application form to be updated for applicants to demonstrate their intent, and staff projects there will not be an increase in licensing workload related to the new provisions of this bill.
Any questions?
Well, it's me again. So I think our turnaround time for applications is what, 30 days or something, or less than 30 days? So I don't think we have any throughput or bottlenecks that have been identified, and don't think necessarily that this is needed because we're able to turn over applications pretty quickly. And that really is a testament to the leadership here on the board. Thank you to the staff for being able to do that on time. So I don't necessarily think that this is going to fast track that, because I think you folks are doing such a great job already. So for those reasons, I would oppose.
Would you like to make a motion?
Yes, I'll make a motion to oppose.
All right, so we'd like to make a motion. Would someone like to second?
I'll second it.
All right. Is there a public comment? Oh, I'm sorry. Christy Slade? Shields?
So I just want to remind the board, anytime we have an expedite requirement, we'll need to put it on our application, which means we'll need to go back and amend your currently proposed regulations to add these requirements. So it'll need rulemaking to support it. And so there will be a workload associated with that. I don't know if the board's staff have considered that, but all the expedites you're seeing in these bills will add workload because of the rulemaking process that we have to go through to adopt it and make clearer maybe some of the ambiguities that are in the text currently. So
Excellent.
just adding that for
Okay.
consideration.
Thank you.
Excellent. Public comment.
This is the moderator, not the direction of the board. I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests, would you like me to close that Q&A panel?
Yes, thank you. Okay, Ms. Hurd, will you call for a roll call vote?
Charles Alexander,
Aye.
Juan Armenta,
Aye.
Sonia Early,
Aye.
Diego Insunza,
Aye.
Vasco Diankit,
Aye.
Deborah Snow.
Aye.
Excellent. The motion is carried to oppose this legislation. And D.
Okay, moving on to AB 2581, Healing Arts, Continuing Education, Maternal Mental Health. This bill is similar to AB 2270, which we just discussed. And this bill would require the above specified boards in determining their continuing education requirements to consider including a course in maternal mental health. And in regards to fiscal impact, staff does not anticipate any fiscal impact.
And did this come up last meeting? It was just similar to,
It was, I thought it,
This is similar to AB 2270.
okay.
So
that's
item
what I had.
B.
Okay.
Mhm.
yeah, and for
Okay.
the same arguments that are articulated for the
Right.
prior, for me, I still plan to oppose.
Okay, would you like to make a motion?
I make a motion to oppose.
Is there a second?
Yeah, I'll second that for the same reasons. Yep.
Excellent. Is there public comment?
This is the moderator, not the direction of the board. I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests, would you like me to close the Q&A panel?
Yes, thank you. All right, Ms. Hurd.
Charles Alexander,
Aye.
Juan Armenta,
Aye.
Sonia Early,
Aye.
Diego Insunza,
Aye.
Vasco Diankit,
Aye.
Deborah Snow.
Aye.
Excellent. That motion carries to oppose this legislation. Ms. Dillon.
Okay, so item E is AB 2862, licenses African American applicants. This bill was introduced on February 15, 2024, and is located in the Assembly Appropriations Committee. This bill would require boards to prioritize African American applicants seeking licenses under these provisions, especially applicants who were descended from a person enslaved in the United States. This bill would repeal those provisions on January 1st, 2029. And in regards to fiscal impact, the bill would require staff to update the board's licensing process to ensure applicants who meet the expedite criteria can get their license application expedited. And this would require the license application form to be updated for applicants to demonstrate that they qualify. Staff projects that there will not be an increase in the licensing workload related to the provisions of this bill. However, I would like to add that regulations may be required to specify the provisions of the statute that is required under this bill.
Any questions, comments?
Well, for the same reasons as the other,
Yeah.
the throughput is, and
Right.
yeah.
Excellent.
Comment? So I support the approach we used to the prior related bills about expedited. I do understand the potential motivation for this, but Med Board, like PA Board, is doing very well with their time of licensing. So it's really no advantage. It would be a optics that we can do other things for optics, I think.
Excellent. Yes. I think we'd all agree. Is there a motion to second?
Second.
Oh, Christie.
Oh, Christie.
Yes, sorry.
So the regulations you spoke about, the problem with the bill is it doesn't specify how we would verify someone's descendant from a slave, an African-American slave.
Right.
So that is one of the reasons some of the other boards have opposed because of the difficulty in figuring that out and how would they approach it.
Mhm.
And there's no guidance in
Right.
the analyses for the bill as to how they would approach it. So I'm not sure what rule we would write to do that other than self-certification, which,
Mm.
you know, one of the other boards has explored, but then you have the opportunity for people to maybe
Right.
get the benefit that don't really qualify.
Excellent. Well, I
So-
do think that we've already mentioned, I thank you for that information, but we don't have a throughput issue and we have, everybody's usually certified within less than 30 days. So, but yes, thank you so much for that. But I would have to agree, we would not have the ability to find that information out in a timely fashion and which might decrease the time to to find that information and have our numbers still continue the same. So,
Ma-
yes.
Just briefly, just to be clear, the bill would not require that proof because it says it shall prioritize African-American applicants seeking licensure, especially applicants.
Mm.
But I guess it would if you,
Exactly.
I think that's vague.
Right.
Because it's a classification that
Mhm. Well, thankfully, again, we don't have a throughput issue. So most of our applicants are licensed within 30 days. So I think that's a moot issue.
Yeah, I think it's important to note what Christie and Michael just said. If you know, really, this is a statute that sets you up for failure.
Right. And might increase time.
Yeah.
So excellent. All right. So I think do we have a second?
Yes, I second.
Okay. And then public comment.
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests for public comment, would you like me to close the Q&A panel?
Yes, thank you. Ms. Her.
Charles Alexander,
Aye.
Juan Armenta,
Aye.
Sonia Early,
Aye.
Diego Insunza.
Aye.
Vasco Dianke,
Aye.
Deborah Snow.
Aye.
Excellent. Moving on to item, is it G?
Item F.
F, sorry, F.
So AB 3127, Reporting of Crimes Mandated Reporters. This bill was introduced on February 16, 2024, and is located in the Assembly. This bill would remove the requirement that a healthcare practitioner make a report to law enforcement when they suspect a patient has suffered physical injury caused by assaultive or abusive conduct. This bill would instead require that a health practitioner make a report when the injury is life-threatening or results in death, as specified, or is the result of child abuse or elder or dependent adult abuse. The bill would require that the health practitioner additionally make a report when a person is seeking care for injuries related to domestic, sexual, or any non-accidental violent injury if the patient requests a report be sent. The bill contains other related provisions and other existing laws, and it would also require a health practitioner who suspects a patient has suffered physical injury that is caused by domestic violence to provide brief counseling and a referral to local and national domestic violence or sexual violence advocacy services. In regards to fiscal impact, the board would need to provide an update of mandated reporting information and be included on the board's website for licensees. And this is something that can be done by staff and supported by the board's current pro rata cost of DCA.
Comments?
Could,
Yes.
what is the rationale that they gave for this bill? To take away the reporting to law enforcement? I'm just curious why they want to
So
take away that.
This is a similar bill that we had discussed, I believe, last year. I believe the rationale is because the victims in this situation, they would like to, instead of just contacting the law enforcement and reporting it to them and then giving, them the information and having them deal with it. This would allow the healthcare practitioner to provide brief counseling and referral to local domestic violence or sexual violence services, which would better assist the victim,
Okay.
they believe, so.
Rather than requiring it to be to law enforcement
Correct.
as it is. now.
Which that is still, the healthcare practitioner is still able to do that.
Right.
There's no,
Okay.
Right.
but this is just. it's
And most
specified.
practitioners do that.
Mhm.
Yeah.
It's kind of interesting. The latter half is very, very important. I think all would agree with that, this counseling, blah, blah, blah. The first half is problematic. You're asking the individual to make a good for felt report of some type of behavior that probably would be reported. So I don't know why I understand why you might couch it that way, but it seems problematic because I have trouble with the beginning of it, don't have a problem with the second part of it. So
This duty, if I'm not mistaken, already exists.
Yes.
Correct.
Mhm.
And this just adds another quagmire, I think, to the practitioners. That
like
puts
your
them in a
wording.
position of making an assessment. And in my view, also infringes to some degree on the physician and patient psychotherapist privilege, which we want to encourage people to know that they can talk to their psychotherapist or physician without fear that, boom, it's automatically going to be reported. So I think from that perspective also, I would oppose this.
All right, would you like to make that motion?
I will make that motion to oppose this.
Excellent. Is there a second?
I'll second.
Okay, is there any public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests for public comment, would you like me to close the Q&A panel?
Yes, please. Thank you. All right, Ms. Herr.
Charles Alexander,
Aye.
Juan Armenta,
Aye.
Sonia Early,
Aye.
Diego Intunza,
Aye.
Vasco Dianke,
Aye.
Deborah Snow.
Aye.
And that, we oppose that vote. Exactly. All right, moving on to G, SB 1041.
Okay, SB 1041, Physician Assistance Licensure Armenian Doctor Pilot Program. This bill was introduced on February 7th, 2024, and is located in the Senate Appropriations Committee and was amended on April 8th, 2024. This bill would establish the Armenian Medical Graduate Physician Assistant Training Program to be conducted at an appropriate educational institution or institutions. The bill would require the board to establish a training program advisory task force, which the bill would require to develop and recommend curriculum for a training program. The bill would make an Armenian medical graduate who is either a citizen or permanent resident of the United States and who has satisfactorily completed the training program eligible for licensure as a physician assistant if the person has also successfully completed a certain written examination. The bill would require that funding necessary for the implementation of the program to be secured from nonprofit philanthropic entities as specified. In regards to fiscal impact, the bill would require staff to update the board's licensing process to ensure applicants who meet the training program requirements are licensed. This would require the license application form to be updated for applicants to apply for the training program. This bill would also require the board to establish a training program advisory task force. However, until funding is secured from nonprofit philanthropic entities, the board will not be able to establish a training program advisory task force to implement the program. Therefore, it is difficult to determine the exact fiscal impact, if any, that the board can anticipate. And in regards to board position, at its March 4th, 2024 meeting, the board took an opposed position on this bill, and the position letter is attached in attachment 2.
Excellent. We will continue with that opposition.
Just briefly, Ms. Khan and I were noticing that just in the last couple of days, there's been some action on this bill. It had a hearing on May 16th in the Assembly Appropriations Committee. It was held in the committee. It did not pass out of the committee, and it therefore missed the appropriations deadline and is effectively dead.
Yes. Excellent. Very good. All right, moving on to H.
All right, SB 1067, Healing Arts Expedited Licensure Process, Medically Underserved Area or Population. This bill was introduced on February 12th, 2024, and is located in the Senate Appropriations Committee. This bill would require each Healing Arts Board to develop a process to expedite the licensure process by giving priority review status to the application of an applicant for a license who demonstrates who demonstrates that they intend to practice in a medically underserved area or serve a medically underserved population. In regards to fiscal impact, this bill would require staff to update the board's licensing process to ensure applicants who meet the medically underserved area or serving a medically underserved population criteria can get their license application expedited. This would require the license application form to be updated for applicants to demonstrate their intent, and staff projects that there will not be an increase in licensing workload related to the new provisions of this bill.
Excellent. Do we have any comments or questions?
Yeah, I think for the same two reasons, for the same two reasons that I think all as board members discussed, which is, there's really no need for an expedited process because our turnover is so good.
Excellent. Is there a second?
Second.
Awesome. Public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no request for public comment, would you like me to close that Q&A panel?
Yes, please. Thank you. Awesome. And Ms. Her.
Charles Alexander.
Everybody wants to expedite, huh? Aye.
Juan Armenta.
Aye.
Sonia Early.
Aye.
Diego Insunza.
Aye.
Vasco Dianque.
Aye.
Deborah Snow.
Aye.
And that approves that apposition for that letter H, SB 1067. Ms. Dillon, thank you so much for your wonderful legislative update. I appreciate it.
Madam President,
Yes.
I think we should open for public comment one more time.
Oh, okay.
On the entire report.
Okay.
There were some bills we didn't take position. on.
Excellent. All right. Is there any public comments for any of the bills that we discussed earlier?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests, would you like me to close the Q&A panel?
Yes, thank you. All right, now moving on to item number 16, agenda items for next meetings. Do we have any things that we would like to discuss? I can think of.
Shall we continue our discussion?
Yes, that is
Should we
great.
continue our discussion? Yeah.
Yes.
If the board is in agreement, I would, yeah. Yeah, okay.
Yes, I would love to continue our discussion on ratios. If that's okay, we can put that.
You'll burn some more information. back.
Yes, sir, I will.
Thank you.
You got it. Thank you.
Any other items? All right, is there a public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests for public comment, would you like me to close that Q&A panel?
Yes, thank you. And lastly, there are no closed session today. So we will adjourn and conclude the Physician Assistant Board meeting. Thank you all for attending, and we'll see you at the next board meeting. And we will stand in adjournment at 11:38.